So I don't know if I relaunched it or not. If you want to take it over, that's fine. Yeah. Participants, now they're coming in. You want to take over? Coming in on the right. Can I start this on my phone?
Hello all, I apologize. We're having tough technical difficulties.
Okay, I'm back in.
Perfect.
Yeah.
Kristen is back in, I should say.
Thank you, Kristen.
Just so you know
Yeah.
what we're doing, we had, somehow there was a conflict on our computer that they thought I was still in a meeting from last week.
Oh, yeah, you know what? When it cut me off, that's what it said, that you were in a meeting. And I'm like, hey, I'm supposed to be there. Wasn't supposed to be at that one.
Right.
This one.
So we're expecting about 49 participants today, and we're only at 17. So I think with all of our craziness, I'm gonna wait for just a few more minutes to see if we can get everybody else re-logging in.
Can you see me, Kristen? Can you see Kristen?
Let's see.
I think I'm unmuted. This is Jim Hudson.
Kristen Tellefson, no.
No, hun, it's just your names up there.
Oh, okay, so you don't need to see us.
No.
Okay.
We'd be happy to, yeah, but no.
Oh, okay. Somebody else said that they could see me.
I can see you. Do you see me, Loretta Zudi?
I do see you. Mm-hmm.
Can you see Larry?
Hi.
Can you see Larry Grant?
No.
No.
Oh, wait.
How do I get in?
You're in because I can hear you.
Yeah, but I can't see anyone.
You just turn on your video. So in the top little corner right there, there's 3 dots, and it'll say, or at the bottom, stop video, video. It should have yours isn't on, so it has a red line down the bottom.
Video.
Where it says chat?
Yeah, well, there's a bottom, I don't know what you're using.
Oh, it says start video. Mine is off.
Yeah.
You're not on.
There I am. Okay.
Oh, okay. Let me try and do mine now. But you guys said that you could see me. Is that right? You guys are laughing at us.
Can you see me?
Yes.
I can see
I
you.
can see you.
Me?
Okay.
I can see 4 people now.
I can't get back on.
Hi, my name is Jim Hudson. Can you hear me?
Yes.
Yeah, I can hear you, Jim.
Okay.
Kristen can hear you.
I've got my video off. I chose to turn it off, but I can hear everybody and see the people who are logging in. So I'm here.
Okay.
Shrink our screen.
Oh my gosh.
It's 9:19.
You gotta get the screen share. Can you get into the screen share? You know, maybe if I just move the screens around, I could do it differently. So. Can everybody see a green accounting workshop form?
Yes.
Yes.
Okay.
Yes.
Yes.
So we need to admit more people. We've got did everybody download their materials? I hope.
Yes.
Yes.
And the 319-page conservator book.
Oh, you got the whole book?
I did. I printed it out.
Okay. Yeah, we don't usually leave the link for that. We put it on our cover page. It says Handbook for Conservators. And that's the material we're using today to teach. It's
Oh,
tape.
okay.
approved by
Yeah.
the judicial
Yes.
council. And that's,
Yeah, that's me.
the judicial council is board of directors for the Supreme Court of
Okay.
California. It's very
Yes.
authoritative.
What did you send me?
They
Did you
updated.
send it to james@versatape.com? And did you send it about your logs?
Okay, so what I sent
Oh, I did
was
not get
the
it. I didn't
outline.
get it. I apologize.
Sure.
The
James,
outline,
mute
we sent
yourself.
two items. One is a schedule says court accounting. It's a file dated 8/12. And the other we sent was another handout.
No hyphens? Oh, no, just
And I sent it last
james@versatape.com.
night. I
No
sent it
AOL.
to James, to info, and to Rich.
Yeah, I got it.
Got it. Thank you.
The one I have is the paperwork that, let's see here. Let me
Starts out with a flyer on the first page, and on the second page says handbook for conservators.
It's right here.
Yep.
Oh, yeah, right. Absolutely. Yes. It's this one.
Great. Does anybody still need to get on that page in their materials?
What page are you on? Pardon me.
The one that shows on the screen, handbook for conservators.
Got it. Thank you.
Okay.
Am I involved in the class at this time?
Yes, you are. Is this
Okay,
Letitia?
yes, it is.
Hi, I called you and left a message for you to come pick up the material at our office, and I didn't see you in, but I'm glad you could make it.
Oh, okay. You know, I was out of town. I had some business I had to attend to. So I
I'm
do have the
sorry.
handbook.
Okay, good. You're all right then. Just go, let me tell you what page to go to. Appendix C. Appendix C1.
Is that in the handbook for conservators?
Yes, ma'am. Should be in the back.
Is that Appendix D? And I don't see it. Okay, I see Appendix C, yes, right here on the first page.
Great. So that's where we start. Okay, Tammara. Whenever you'd like to start.
Okay, sorry guys, we got started a little late. I know there are quite a few of you that are from CALDA who are actual legal document preparers, assistants, but there are a few that are actually taking the class because they either have a guardianship or a conservatorship. So although please don't think that the CALDA or the LDA people are non-important.
LDA means legal assistant.
You're almost gonna have to check in.
But I still, I would like the participants who are actually going through a guardianship or a conservatorship, I'd like you actually just to briefly and quickly introduce yourself and let the rest of us know, like, your reason that you're taking the class, or what are you wanting to get out of the class, or tell us a little bit about your conservatorship or guardianship so that others can hear. And if somebody wants to pipe in and say, I'll go first, I'll take that.
I'll go first.
I'll go first.
Oh.
Okay, who's talking?
Kristen. No.
This
Actually,
is Indra England.
There you go.
Go ahead, sorry.
Hi, my name's Indra England, and I was awarded conservatorship of my mom in 2011. And I have had a lawyer prepare the accounting, and we're approaching the 4th accounting, and I would rather not pay the lawyer. So I'm going to try and do it myself with her as a backup.
Awesome. Awesome, awesome. Anybody else?
Me, I'm Loretta Zudi, and I am a CALDA member. And I've been doing conservatorships for maybe 3 years. And I've only been doing the person, but now I'm into the estates. So now I have to do a.
You have to mute everybody.
Oh, am I muted?
Nope, you're going. Go ahead.
Oh, so now I have to do an accounting, and I don't know how to do it. So this is a great class for me to take. Thank you for doing this.
Oh, awesome. Okay, who's next?
Kristen.
Lakeisha.
Oh. Go ahead.
Lakeisha. I'm taking this class. I haven't been awarded conservatorship of my brother yet, but when I applied for person, but we're in the position to where we have to get some account for like banks, his bank stuff in accounting, so that he can put his money away and get himself together in the best way that we can, since he's been paralyzed now from his shoulders down.
Sorry.
Oh, sorry to hear that, hon. But I'm glad you're taking the class. Okay, who's next?
Kristen.
Larry Grant, can you hear me?
Yes, Larry, go ahead.
Okay. I'm a retired court investigator, and we used to review accountings, frequently for conservatorships. I was good at it, but I was able to kind of muddle through. When I retired, I became an LDA, and I'm helping people prepare conservatorship petitions, and in some cases, I have done some accountings, but I don't feel comfortable with what I'm doing, so I'm just trying to get all the help I can.
Perfect. Okay, who's next?
Maybe it is Kristen this time.
Go ahead. Go.
Okay, real quick here. I was awarded a temporary conservatorship over my mother, who my niece had abandoned into a facility for almost 9 months. I didn't find out, when I found out that she had abandoned her, I got an ETRO and, of course, hired attorneys and got that taken care of. But now she's in a facility. I got temporary conservatorship. I go in on 9/11 for a court date to get permanent conservatorship. And I am just trying to do whatever I can to help my mother. So I'm really I was thrusted into this. It's like by the time my files, yay talk, because I just got bombarded right into it and went gung-ho. So it's been 24/7 for me.
Wow.
That is great, though. I'm glad. I'm glad you're doing this. Are there any more that have a conservatorship or a guardianship going now?
I do.
Go ahead.
Stacy Anderson. I have a temporary conservatorship. It's actually for my ex-husband, who is the father to my 2 daughters, who are 21 and 23. He got in a horrific motorcycle accident 3 months ago, and he's basically wheelchair bound, and his most substantial injury was a traumatic brain injury. He's in the hospital, and I promised my daughters, John has always been my friend. We're not together anymore as a couple, but I promised my daughters we do what we need to do to help him get back on his feet. He's going to be discharged a little prematurely in about 5 days to my home. It doesn't, we weren't able to keep his rental because we had a period of time with no income. We're just going to have to try and take care of him. He requires lifts and wheelchairs, and he's pretty disabled right now. We were hoping to get him more time in the rehab, but they're discharging him, and in order for my youngest daughter to go back to college, finish her nursing degree. She's a senior. I offered with my other daughter to care for John and help them out any way I can with their father, and a little overwhelming. So I'm the temporary conservator. I was a social worker, retired after 30 years, but this is a lot different legal wise, and trying to navigate it the best I can.
Well, we wish you luck, and I really hope that he gets better quickly and it's pretty smooth for you all. I'm going to go ahead and jump in and get started because it's going to take the full time. We may go over a tiny bit. Please understand if you need to leave exactly at 12, which is what it's scheduled to, we won't get our feelings hurt. If you missed anything, just to let you know, which I'll slide back up on this slides, we offer this class several other times this year. The next one will be Thursday, October 15th, and then we are also offering it again on November 19th. All of the classes are exactly the same. So if you take this one and you believe you fully understand everything that we've gone through, then there's no need for any further classes. If you've taken the class and you feel you still want to brush up, or there's maybe something you didn't get or missed, please feel free to sign up for the next class in October. But again, go ahead.
Tell me your name. Your picture says
I'm sorry. Hi, my name is Tammara, and my last name is Brown.
You're
And
Tammara Brown.
currently,
Okay.
I am in LDA, and I work here with Rex Crandell, who is an attorney, and he is the other person who will be speaking in the class.
Okay.
May I interrupt also? This is Jim Hudson speaking.
Hi, Jim.
Hi. I'm handling just a regular probate, and I'm at the stage where I'm getting ready to file the accounting and the final distribution. I'd like to have that done by the end of the month if I'm lucky. But anyway, I find that knowing which schedules to use and how I'm having trouble organizing that material. That's one of the things I hope
We will go through every single one of the schedules and the whole entire process today, that you should be able to muddle your way through completing the entire thing with today's meeting.
Yeah, and I'm hoping that once I file the papers, that if there's something wrong, I'll be able to go online and see what corrections they want me to make before the hearing is
That's correct. The probate examiners will provide any type of further details or further documents that you will need. But we're hoping that after this class, you won't have any corrections. You're going to know everything and do it perfectly.
Great. Well, thank you.
Okay, I'm gonna keep going down the chart so we can get started for everybody else. And I'm apologize. I know we're on a tiny bit of a delay, so I may be speaking a little bit faster than the screen is actually showing, but I can't tell where the delay is. So I know there is one, and I'll give it a little bit of time before I start talking. So basically, we're going to go through and start with the sample inventory and appraisal. That's the first thing that needs to be done when you are appointed a conservatorship or a guardianship. Technically, you have 90 days from the day you are appointed to submit your inventory and appraisal. I can tell you, and I know some of you are not from Contra Costa County, but Contra Costa County is getting a little bit more, not pushy, but they're really enforcing the rules a little bit more nowadays, and they're issuing sanctions when things or accountings aren't filed, or there is an extreme delay in the accountings filed. So we're going to start off with this piece. Again, this is 90 days from the date you are appointed or the date letters are received. Keep in mind, though, that you are not the only one in some cases completing this form. So do not wait till day 89, think you're going to try and complete this form and submit it by day 90, because it's not going to happen, especially if you have non-cash assets and it needs to go to a probate, referee. So again, we'll go through that as we go through the forms, but I want you to realize that you should get started on this right away. And so this is just a little bit of details, stuff you're seeing on the screen that is reiterating what I am saying to you. Okay, so the first form we're going to start with, or the first thing that will be due, is the DE 160. DE means decedent's estate, or a GC, which is a guardianship and conservatorship. I'm looking at these numbers right here. It is this number right here. This is the actual form for your inventory and appraisal that is due within 90 days. Can everybody see my screen okay and everything good?
Yes.
Okay, so I'm going to, please realize the form I'm using is only a sample, and it is a form that was completed by an attorney, but I want you to complete this form as if you do not have legal counsel, and legal counsel does not have to complete this form. You can complete it yourself. So I'm gonna continue through the form, giving you what should be completed as if you were filling this out pro per. Okay, so the first thing you'll do is right here where you see the name Jared Roberts, you would put your name. I would put Tammara Brown, that's all. I don't have a state bar number, unfortunately. Wish I did sometimes, but I don't. So you would just put your name and your home or your address that you're using and the city. Okay, then you'll come down and this is your phone number. If you do not have a fax, leave this space blank.
Can I use the client's number? I mean, name and address?
No, honey, we'll use whoever the conservator or the guardianship or whoever's going in pro per, their name would go there.
Got it. Sorry.
It's okay. So here is an email address. And where it says attorney for right here, basically you would put your own name and then you would put conservator and pro per, P-R-O-P-E-R. That means you're representing yourself or you're filling this out on your own.
I'm sorry, you said even if we have a lawyer, we put ourselves in this spot? We're doing the accounting.
Unless the lawyer is completing this.
Okay.
Okay, down here you would put the court name. So in this case, the example is Orange, but in my case or where I'm at, I would put Contra Costa right here. The address of the Contra Costa Courthouse right here that I would put is the physical address, which is 725 Court Street. You want to include the Department 14 and the room 212. That is the probate department.
Department 14.
In Contra.
Room 212.
Room 212.
That's only for Contra Costa. So others who are not completing for that county would not put that. Okay, the mailing address for Contra Costa is P.O. Box 911. Their city is Martinez. It is California 94553.
What was the room number again?
The room is 212, hun.
And the address was?
The address, the physical address or the mailing address?
Physical address.
So okay, the first line is 725 Court Street. And then the Department 14, room 212.
If the mailing address and the street address are the same, you just put
As in,
same as above?
you would do it just like this is here, your example. They have the same.
Okay.
And it's Martinez, California.
Correct. 94553.
That's only if you're filing in Contra Costa County, correct?
That's correct.
Is this form used for trust accountings as well?
That's correct. It is.
Thank you.
Okay, I'm gonna continue going down. The next box that you will complete is this estate of. In here, you will list who the conservatee is, or if it's a minor, you will list who the person you are doing the guardianship for. If it's a decedent, you will list the person who is now the estate you're working for. So it's that person's name. And then you will mark the box whether they are the decedent, the conservatee, or the minor. You will only have one box marked.
Okay. Use the same box if you're probating an estate?
Yes, this box would be marked decedent.
Okay.
Okay, we're going to keep moving down. There are several different boxes here. Most of the time you will be doing a final. I wouldn't suggest doing a partial. Typically, I mean, it has been done, or if there's a supplemental, which means you had to have a correction or something done, or it was corrected, you would mark these other boxes. But for this example, I'm going to go ahead and show you, you will mark the box final, meaning there will be no other inventory and appraisal that you file. Okay, sliding over here to the right side, you have a case number. The case number, again, is what was assigned to you by the court. In this box down here where it says date of death of the decedent, or the appointment of the guardian or the conservator. So again, the date letters were granted.
Can I back us up just a little bit? In the inventory and appraisal where you said to mark final, could you later on come back and do a supplemental also?
Yes, son.
Okay.
But you'll see that if we go through the form, what is the purpose you want to do a supplemental?
That's just more of an update on his account.
No, it wouldn't be a supplemental, hun. You would explain that in your accounting.
Okay.
This is one point in time.
And if it's a temporary appointment, you put the temporary appointment date in there?
You start, yes.
Yes.
Yeah, but wouldn't that be
hun,
for I'm sorry, wouldn't that be for it would be for a cash account. And with a cash account, that would begin with just his bank account and what he has in his bank account at the starting time when appointment of conservator was given. But after that, because that's done within 90 days of your appointment. But after that is done, then maybe within, a period of time of maybe if there's an argument or something within, that time, because the individual is paralyzed from the shoulder down. So he has
Okay.
no way of doing anything unless it's presented to him like we're having class right now. So I'm thinking of a supplemental to kind of go over and have someone as a second party, which they do play, the courts do play a second party within the conservatorship award. So why not play it also within the access? So if something was to cause a problem or anything was to come in, to allow them to help us to solve the issue that we're going through. And it also has something to do with, I think it has dealing with your insurance, dealing with your Medi-Cal and stuff like that, of different stuff that all involves that area.
Yes, and you'll realize going through this form, if you just let us get through the form, you'll realize where those corrections or where that take place. I just want to let you guys know, this form that you are completing is only represents the exact day you were appointed. It doesn't represent the next day. It doesn't represent the day before. It doesn't represent anything except for the exact day you were appointed. All this is telling the court is the day you appointed me, what did I start with? So even if there is a correction, or there's more found, or there's a different value that is found than the day you completed this, that is all reflected on the accounting, which we will get through as we go along down. So if you just follow me through this form, you will see and get all your other answers, questions answered. Again, you are only telling the court, this exact day that you appointed me, as soon as you appointed me at court, I went over to this person's house and this is what I found, where I took charge of this person's bank accounts or whatever they have, and this is what I found. This is only a 1 day snapshot, 1 day. Today, the day you assign me this person. So again, if you just let us go through this form, you will see if there's any corrections or any adds or any things that need to be corrected. You'll find the place that you would do that. Does that make sense?
Yes.
Okay, so I'm gonna keep going on because we won't get through this class, okay? So, okay, you will mark this a final, and again, I'm gonna keep going down, and here's where the really important part starts getting together. So, the next line is your appraisals. You're telling the court, what do I have, okay? This first line is to be completed by you, see? Total appraisal by the representative, the guardian, or the conservator, and you'll attach schedule number 1, which I will flip to in just one moment, and there will be a total here. So again, this first line, I'm going to switch and go down to that schedule. It will look like this. Again, it's called the DE 161 or the GC 040. You will need to put the state name that we copied from this page 1. This name here will be the name you follow on the top of all your other forms, okay? So again, that name will go right here in the state of. Are you there? Are you guys all with me?
Yeah.
Yes.
Okay, so then you want the case number. Again, that's the same exact case number that we put on this line right here. Here's right here, this case number will transfer forward to here. And we'll start our inventory and appraisal, okay? So on this screen, what you will do is you will tell the court everything that you found of the conservatee, the guardian, or the person. You have to tell them, what do you have and what do you have right now, today, only today. So again, I found cash at the house. This is the you would say where you found it. So say for instance, you went into their house and you found they had cash
in their wallet. Okay, you would put the conservatee's address and how much cash did you find on them. Please understand, I'm giving a lot of examples here. If you don't have these examples, don't put them in. You'll only indicate ones that you have. So whereas I have 6 examples, if you only found cash, then you'll only have 1 line item. Okay, so don't think you have to have all these line items. Okay, number 2 says the balance in the checking account, please provide, I always state only provide the last 4 or 5 numbers of the checking account. And the reason being is when you submit these documents, they are public record. I right now can walk to any courthouse records department and I can pull any case and find out every single thing about that person. I don't want you guys to have people's entire bank account number out to the world or to where anybody can pull it and grab it. That's a little bit of a security factor. The courts do allow and do understand that if you only include the last 4 digits, and I will tell you the reason why a little bit later with the petition, because you will be attaching actual bank statements, they will know how to find and match what you're saying. So please remember, only include either the last 4 or 5 digits of the account number for your protection and for theirs, okay?
But if you're
I also
attaching
like
the bank
this.
statement, the whole number is going to be on there anyway.
I'm sorry, hun, repeat your question because you're really light on your volume.
On there anyway.
Okay, if you attach the bank statements, so anyway, they'll get the whole number.
The bank statements do not, the bank statements do not become, and we'll show a little bit later, you will do what's called redact, which means that you will cross out the bank account number on there.
Okay.
The courts don't care what the actual bank number is, they just want to see it matches.
Got it.
Okay, so we're going to keep going. So I've listed here, like say for instance, you have a Wells Fargo, Bank of America, you will just list the name of the bank, and it's not 100% important that you state the branch where it's located, but it is nice to know. Okay, so what that means.
Which page are you on?
Page 7.
It's page 7, hun, lower left.
Okay.
You will see, I'm gonna slide down the screen so you will see it. See these numbers down here? This is what I'm calling page 7.
C7.
Or C6 is the actual if you go by C, but I wouldn't do that. Go by the Bates number.
For this class.
On the bottom of my form, it says C7 in the right-hand corner. But I don't see where it's
Go one page. Go one page back.
One page back, yes. C7 is attachment number 2, hun. We're not there yet.
I don't think I have that one in my packet.
Tammara, I was going to tell you on the printed out ones, because I printed out mine. She may have the same as mine printed out. It does not have those numbers that you have, but it does read down below C6.
Okay, sorry
about
that. We did.
No.
Is that the page that says inventory and appraisal attachment number, and then it says 1?
Yes, ma'am.
Okay.
Tammara, I wonder if they know what Bates numbers are. They understand.
I'm sorry. You wanted to know what is?
I'm wondering if they know when you say Bates numbering, if they know what that is.
Hi, Leslie. Yes, sorry, hun. That's just a number that we use as an order. And so we did it because these numbers down here get kind of mixed up as we go through this whole accounting thing, that we did our own numbering, but some of you don't have it, and I apologize. So we'll try and make sure you're still on the same page we are.
Sounds good to me.
Okay. So I'm gonna keep going forward. The next example is a savings account. Remember, the day you get assigned or receive your letters, it is up to you to find out from the bank on that exact day what the balance is. You are not allowed to go wait till the end of the month and get a bank statement and then try and figure out. That's not what this form is asking you. This form is asking you the exact day that you are appointed, you are responsible for this amount of money, and they want to know what it is. So it's best if you figure out and call the bank, or if you waited and do it the next day or so, you would want to ask the bank what was the balance on the specific day you got appointed. Again, this is a point in time and the day you got appointed. Please do not provide any other numbers or you will not balance on your accounting. Okay, let's go forward. Number 4 shows an example of a certificate of a deposit. If you have one, great. You would list what is the amount. Another example would be that if you got there and saw the mail and you see that there's an uncashed retirement check that has come in, you would put that here. I do realize that nowadays they're doing direct deposit, so not many people would have this, but just in case checks still arrive at the residence or what have you, there could be a, say for instance, a paycheck if it was an accident that happened and they mail them their paycheck or something. It could be anything. So if there you find, again, this is only the day you walk in the house, you received your letters and you find this. This is not the next day or days later that happens. Okay, so the next one again is an uncashed Social Security check. Again, those are now direct deposited most of the time, but just in case, that is here. And if there was a refund or a dividend check or any type of refund check or anything that you find in the mail that's actual cash. Okay.
Is that going to be different than our bonding account?
Yes.
Okay.
Okay, so then what will happen after you have all your totals along the line and you say, again, this is only cash or cash equivalent. We will get into furniture, fixtures, property, stuff like that later. This is only cash assets. So down at the bottom, you will see total cash assets, and you will put the number, which is the total of all of your cash assets that you've located. That number will go down here. Does everybody see the 57,844.59?
Yes.
Okay, it's what's really important is this number that you see down here will be the exact number that you transfer back to the inventory and appraisal page 1, and I am right here. See how these numbers match?
Yes.
Okay, so we're all there. So we got our first number we put in. The second number or the second line says the total appraisal by the referee. And it says it will be on attachment number 2. Now, I will tell you one thing, it is left blank, and it is left blank on for a reason. So if you will slide down or turn your page and go to what we're calling now C7, which somebody else asked before, C7, this is our bait stamp number 8. This is attachment number 2. And we are going to go through completing this now. Again, remember I said the estate will be the same name as on your first page. You will provide the case number. This is a pre-printed form, so you don't need to worry about putting any of that, except for you'll name one of one or what have you. But what's really important is on this page, you are going to list all non-cash assets. And we'll go through what are non-cash assets. Okay, so my first, again, these are only examples. If you do not have all of these, don't put them or don't go looking for them. This is only you're stating what you have. Okay, so it states I have real property, and you'll want to provide as much description as possible. Remember, you're sending this off to somebody else who is going to give you a value for it. So if you just say, yeah, I have a house in Walnut Creek somewhere, there's not anybody in this world that's going to know where that somewhere is and how to give a value for it. Okay, so you have to be really, really descriptive. So there are things like you can use the assessor's parcel number, you can use a property tax, you can use, if you really only know the address of the property, you can use that. Sometimes they'll be able to find it. They may call you and say, I need more details. But again, list as much information as you can for that person to value your property, the probate referee. Okay, and I'm sorry, let me back up a little bit. A probate referee will be assigned to your case at the same time your letters are received if you state that there is, and typically a judge will ask if there's any non-cash assets, and they will assign a probate referee. So it'll be at the bottom of your form. Usually, it will list the probate referee's name and a phone number, and that's who you're completing this for.
Can I ask a question?
Yes.
Would that include shoes, clothes? I don't see any of that
Yes,
kind of stuff.
son. Yes, we're gonna get to that. Yes, it would. Okay, so again, let's start up at the top. You'll just name the address. You will not give any value whatsoever. You'll leave that blank. This is not your responsibility to value. Okay, the next one, example list, there's a vacation home. Again, you'll put as much information as you can about that vacation home. We're going to move down to number 3, which is important, and it says the household furniture or furnishings and where. So basically, this is a lump sum which will include grandfather clocks or antique chairs or china cabinets or what have you. That is not for you to value. You're just going to tell the probate referee that there is household furniture and furnishings at that property.
These are non-liquid assets.
That's correct.
Like bonds and mutual funds.
Correct. We'll get to the, we'll show you this next example. Number 4 is the mutual funds. Again, that's not for you to value or for you to figure out. That's for what the probate referee's job is. So you will only list, if you know how many shares are in safeguard safeguard investment mutual fund. If you don't know the amount.
Oh, sorry. Can I ask a question about the furnishings? So John was very sick and things happened really, really, really fast. And we didn't have, he doesn't own a home or anything. He had a rental property. So my girls and I, we couldn't sustain it. And so we put in notice. Of course, we then placed all his belongings in a storage. And when I got temporary guardianship, I just threw a rough number what his furnishings may be worth. Do I mean, he really doesn't have anything, but do I just put
is it gonna look terrible? I'm gonna put household furniture and furnishings and then put the thing of a storage unit because we could.
No, that's perfectly fine, hun.
Rental property.
That's perfectly fine as long as why the address or where it's at. Typically what happens is a probate referee will do a drive-by or will go figure out or take a look at what it is because he has to place a value on it. If it's a storage unit.
Awkward. It's all boxed.
No, hun, if it's a storage unit or something like that, more than likely what will happen is he'll call you and ask, okay, what's in there? And then he'll do a value for you.
Okay.
Would insurance policy also be included in number 4?
Yes, son. Okay, so another example would be savings bonds. And another really good good example, which I always laugh about, is number 6 I have down here is a diamond ring. Now, let me just tell you the importance or why I put that in most people say. If you have grandma and you have a bunch of grandkids and stuff like that who is seeing grandma running around and she's got like a 5-carat diamond ring that she always wears and you know it, you see it, then all of a sudden at her passing or any time later, you come up with, oh yeah, it's time to distribute. And somebody says, oh, I want that 5-carat diamond ring I always see grandma wearing. And you say, I only see a very small, tiny chip one here that's 1 carat. Somebody's in a little bit of trouble because somebody's looking for a 5-carat and you come up with a 1 carat. There's going to be some questions asked. So I like to state, because diamonds are typically worth quite a bit, I typically like to state what it is, the size if you know. Here is my trouble. I don't know, I'm not a diamond person, so I don't know that I'd know a 2 carat from a 5 from a 1. I wouldn't. And so do your best guess and maybe send, if you can send pictures. This just protects you from later on somebody, and it comes up all the time, somebody says, oh, I remember seeing grandma running around. Now, if you find it and you say, yeah, look, it's really, it was a fake ring, you know, it's not really worth anything, that's totally different. But everything that you show here means you've accounted for it and nobody can say there's anything different. Now, again, that doesn't mean later you may discover that there's 5 2-carat rings and you only listed 1. Well, then that's something we can correct later on in the accounting, and I'll show you where to do that. But for this
John,
example,
you need to go through his jewelry box and list whatever's in his
no, only if it has like pretty significant value. You can list just jewelry and give like maybe take a picture of all the jewelry and send it to the probate examiner and he can give a value. You're not responsible for the value, you're just responsible for reporting it so that nobody says later that it walked off.
I also, on the mutual funds and all that, I just have been really worried about John's care and going to the hospital and getting him ready to bring home.
Okay,
I haven't gone to like and found out about mutual funds or retirement or any of that. I need to do that.
Yes, that is your responsibility. The day that you are appointed a temporary guardianship, that's your job, that's your responsibility.
Okay.
Okay, we're going to continue on. So now that we've listed every non-cash asset that we know of, right, there is a line down here that says total non-cash asset. You will see that this is blank over here in this, because it is not for you to complete. Again, hun,
Do not put totals. Leave this blank. It's not your job. And we'll go through why and how a little bit later on as we complete the form. So again, going back, I'm going to go back to the GC 160 or the inventory and appraisal. And if you will see where it says attachment 2, and I know you guys are on a tiny delay, sorry. So when it says attachment 2 right here, you have left this blank.
Do we pay for the appraisal from the court, or do they just do that at a
The
time?
probate referee, yes, you will need to pay the probate referee his fee. You will get reimbursed later, but you must pay the probate referee.
If you have a fee waiver?
Even if you have a fee waiver, I believe the probate referee has to be paid. They are independent. They don't work with the court or get paid by the court.
Oh.
Wait, do they not charge you if it's all cash though? If they have,
if there is nothing, meaning there is no non-cash assets, you wouldn't even call them or send them this form. This is only if you have non-cash assets. Your form may look just like this. You only have cash.
How expensive is it?
I'm sorry, one more time, hon.
How expensive is it to pay for somebody to look at the stuff?
I want to say maybe 100, 150 at the most, unless we have him traveling all over down south and all over the place. He wouldn't even travel. More than likely, he's just going to look stuff up on the internet and give a value.
Okay.
But they're not a whole lot. But again, I think it depends on what county, what city, what, you know, because they're independent. They can charge what they want. But they work for the courts and they know they can't, they're not they don't get lawyer fees, if that's kind of your question.
I have a question,
Okay, I'm
Tammara.
gonna keep, yeah, hun.
Real quick, you said, okay, the probate referee, going through Contra Costa County, they'll just assign me one once I fill out all this paperwork. Is that correct?
Yes, ma'am. They will at your court date.
Got it.
They rotate probably, I'd say approximately 5 or 6 different people they'll rotate through and provide you with, but they have specific probate referees that they use, and you will need to use the one they assign to you. You can't just pick your own.
Sure. Great. Thank you.
Okay, so let's keep moving on. So you will again leave that blank and continue to complete the rest of your form. So now we're going down to the declaration part. And the declaration part says attachment 1 and 2 together are true and correct of all of everything I have. I'm not doing apportionments. So everything I have, and I truly and honestly appraise to the best of my ability. It's not saying I'm an expert, so I know what I'm doing. It's saying to the best of my ability, I valued attachment number 1, which is again this number, and that means all the cash. Okay, now this is the one that's the other one, and it depends on a probate referee or not. If you told the court you only have cash, there's nothing else, and they did not assign a probate referee, then box number 4, the first one, which states no probate referee is required, would be marked. If a probate referee was assigned to you, this box to your right will be marked, and you will need to know the date, which would be the date of letters or the date the judge assigned the probate referee. Is everybody on the same page? Everybody got it?
Yes. But
okay,
we won't
I'll
know.
keep moving on.
Okay.
Sorry, go ahead.
I was just gonna say, Tammara, is so we really can't check that until we find out if it's gonna be ordered by the court. Is that correct?
That's correct.
Thank you.
Okay, so now we have this next box, which is number 5, that has to do with the property tax certificate. This does not apply to guardianships, conservatorships, but it does apply if you're doing a probate and you are an administrator or an executor. Then one of these boxes must be marked depending on the case. If you are not doing a probate or an estate, leave this box blank.
That's a report death property.
Now we're going to keep moving on down the form. Again, this is stating I declare under penalty of perjury. And what's very important is, one, the date needs to be completed. You can type your name here, but you will not, and this is important, you will not sign this yet until you get this form back from the probate referee. Do not sign ahead of time, okay? You can put your name here, but leave this blank, because again, you're sending this form to your probate referee, if you have one. If you don't have a probate referee, you're free to sign this, date it, and then we move on. Okay, we're getting towards the bottom of the form now, and this says the statement of bond. Okay, in some cases, which if you're court appointed, it's very rare, a bond will be waived. Most of the time, if you are going through court and you are ordered by the judge or given a position by the judge, it's not often that they'll waive bond, but in some cases. So in that case, most of the time, number 7 will be marked. You will put a checkbox here, or a check here, and you say, I have filed my bond amount, and you will put the amount of your bond. Now, I will tell you, there's many cases that you put the amount of this bond of what you think it is, and then you'll find out later, once the probate referee, or once you get your calculation here, your bond might not be enough. Say, for instance, you didn't know what was in the person's account, but you told the judge, oh, I think there's about 30,000. Or you say, I didn't, in court, you say, I don't know how much they have. I can't tell you if it's $1 or $20,000. Then a judge will give what is the minimum bond amount to you and tell you that you have to at least get the minimum bond amount to get your letters. So you go and do that. So say, for instance, they state $25,000 is the minimum bond that I'm gonna make you obtain. Well, then you find out you have $57,000 of cash. So I'm gonna let you answer the question. If my bond is for $25,000, is my bond sufficient for the amount of $57,000 in cash?
No.
Correct. Yay. So in that case, you would put this box right here. You do not have a sufficient bond for the amount of cash you have. Now, what that tells the judge, you do nothing else. All you do is mark a box. That tells the judge at your next court hearing whether he will force you to increase your bond amount or not. I will tell you most of the time that will be yes. The purpose of the bond is to make sure that no money walks away. And I will tell you, I have many cases right now going that money walked away. And we don't have a bond because bond was waived. And now we've got to figure out how to get money back that's already been spent that they don't have to give back and what we're going to do. And it's a very ugly, ugly situation to be in. So
I have a question. On John didn't really have anything and they waived the bond. But when I honestly have not checked into retirement, and I know he doesn't have much in a 401k, but once I add that in, is there a possibility they can charge me bond based on funds that he doesn't have access to or I really don't?
you will have access to those funds, believe it or not. Once you get your letters, you're authorized to transfer, cash them out, or do whatever. You could get in a little bit of trouble depending upon what you used them for, but you do have access to them. So it could be that they will require a bond after the fact. Because if you think about it, what should happen is if you, say for instance, needed the money and turn the bonds into cash, what's to protect the cash then from walking away? There's nothing.
Yeah.
So a bond is only to protect or replace the cash if it should get feet and walk away.
Yeah.
So if you get,
money,
when you get the
help John,
letter,
and I'm just like worried about having to owe money now because we just don't have any left. We don't even know if all his medical equipment is going to be covered in the next 4 days, so we could bring him home. Just
And that is
unknown
something.
fear.
That is something you can explain to the court later, and if they require a bond or not, that'll be up to them. But right for this purpose, you're just filling out this form.
Okay.
So you said you hit insufficient, is that right?
That's correct. I said in my example, if my bond amount was for the minimum bond amount of $25,000 and my cash I find out is $57,000, you have an insufficient bond amount because your bond does not cover all the cash you have access to.
Gotcha, thank you.
so when I get the letters, I can go to the bank and put the money that they have in my name. Like they can be transferred, or do they still? His
I
name?
wish. No, that's a death warrant right there. No, hon, that's a crime. You will go to jail some way. No, hon, you open up a separate bank account for the estate or for the conservatee. You do have access to withdraw the cash or pay the conservatees or the guardians expenses, but you cannot put it in your own name. No, do not mix your funds with theirs.
Okay, that's what I meant, in a separate account, but in their name, not my name.
Correct.
It doesn't have to be a new account.
You don't leave it in their. Do you leave it in their name? Why? I don't have
Yes.
to.
Only thing,
right?
typically what happens is you just leave the account that they have, and they will add that you are. They will add your name to it as the conservator or as the trustee, or depending on whatever your title is, they'll just add your title to that account.
Got it.
So you don't necessarily have to go and open a new bank account. No, you just keep the one rolling that they already have.
Okay, so this client that I have, he has a mobile home. Is the mobile home considered personal property, or is that considered cash?
No, it's considered personal property. That'd be on attachment number 2.
Okay.
Cash is only something that you can go and get rid of real quickly. Mobile home, you can walk outside the door in your hand. That's what a cash item or some type of item is. Mobile home, good luck trying to carry that out the door anywhere.
The bond amount only has to cover the cash, right?
That's correct.
And use cash receipts.
Are we ready to move on? We got it?
Yes.
I'm ready.
Okay, so now the only other thing could be, and this would be if the child is under 18. If you are a guardian for a child under the age of 18, sometimes you will need to state if there's money in a blocked account. Now, for money that's in a blocked account for a minor, or for some other purpose, but typically I'd say 9 times out of 10 it's for a minor. If it's in a blocked account, you do not need to be bonded for that because you can't touch it. In a blocked account, if you try to go to any bank and say, oh, I'm the conservatee, I'm the guardian, I want to withdraw money, they're going to go, nope, unless you have a court order, that money ain't going anywhere. So if there are any funds in a blocked account, you do not use those funds as to state whether your bond is sufficient or not. Because again, you have no access to them. Your bond is only for cash assets that you have access to. And again, the only purpose is so it doesn't walk away. Okay, so now you would come down here. Again, there's another date item. A name. In this case, this is the attorney that was completing it, so he would put his name. But if you do not have an attorney, or if you're not using an attorney, you will put your name here and there will be a signature. Okay, that's page 1. I'm going to move on to page 2 of the form because there's 2 pages to the form plus the attachments. So number 2, or page 2, again, remember to put your headers and what they are and the case number. And there's going to be what's called a declaration of the probate referee. Again, this is only going to be completed if you have non-cash assets. And this is going to be completed by the probate referee. It's not completed by you. So again, once you have this page 1 filled out, and you are ready and you have filled out attachments 1 and 2, you will send all 4 forms to the probate referee. The probate referee will complete their portion. They will fill in the amounts right here. You will get it back with values right here of your non-cash assets. They will also total at the very bottom of the page what your total non-cash assets are. I'll give it time in case my monitor is on a delay. So again, the probate referee will give a total here, and they will come back and they will write the total right here. Okay, then the probate referee will complete this section. They will date it, they will print their name, and they will sign it. Once they have done all that, they will return the entire form to you. And when they return the form to you, you will come back to this section right here, which is up here, and you will sign this and date it. You are now ready to turn this in and file it with the court.
Wow. So you file it and then they send it up to the referee to review and.
No. You send it to the referee, you get it back, and then you file the completed form.
Okay.
Does
So you have
everybody go ahead.
So you
Is
have
everybody
to complete that. You have to complete all the assets portions of it with the referee before you turn it back.
Correct. So this again is only 1 day in time, and this is how you're going to start your accounting. You cannot even really start your accounting without this form being completed, because all the numbers that I showed up top here in these 2 sections will be the numbers that your accounting start with.
And this is the document that has to be turned in within 90 days after appointment.
That's correct.
And we turn that
Okay.
into the place that you had said that the
You
Superior
file it
Court.
with the court. Yes, you file it with the court.
Now I can send that in. Is that correct?
Yes, ma'am. Anybody
I
can
don't-
file these.
Okay.
Anybody
All right.
can file these.
Okay. Thank you.
It doesn't have to be you. It can be an LDA. It can be a process server. It can be your neighbor next door. It can be, it doesn't matter who files it.
What is an LDA?
Sorry, the title is a legal document assistant or a legal document preparer.
Oh.
Do the courts assign you a probate referee?
I'm sorry, do the courts assign you a probate referee?
Yes.
Yes, ma'am. It's at the bottom when you receive your letters.
What if you don't have it when you get your letters? Can I call the court and tell them to give me one? You give me a referee?
Yeah, I would probably talk to the examiners, probate examiners, if you need one.
So that'll be after you're appointed, is that correct?
That if it was not on your letters, which means you're appointed at that point, then you would ask the probate referee. I mean, sorry, the probate examiners.
Can I ask one last question? For an LDA, like I'm bringing John home in 4 days and it's my daughter and I, and he requires 24 hours around the clock care. I'm just kind of overwhelmed right now. If I got to the point where I needed help with some of the paperwork, are LDAs expensive? If I say, you know, this, can you fill out this form if I give you the documents? Is that an expensive thing if I get to the point where I need help?
Can I?
And it depends. Everybody is independent.
Can
Go ahead.
she can go on the CalDA website and she'll look for paralegals are on the CalDA, CALDA website.
Okay.
And everybody charges their own fee, hun. And I believe, I don't know if it's in the handouts because I think that's more towards the bottom. There might be some references if you, references for you, but we'll wait till the end. You didn't include the list of.
Because honestly, I did my own conservatorship packet and it just about killed me. I had to look up every form and try to do it, and my daughters were young and one was going back to college, and you know there wasn't anybody to help John, and I really
that does start.
Yeah,
Okay,
Sarah,
then I'm gonna go off now. I'm done with my portion. Rex will start the completion of the accounting, and I will come back to the petition. If there has been any questions, I apologize because Rex doesn't know how to go through and see what those questions are. But as he talks, if you do have questions that you want to type in a message, I will be reviewing those and forcing him to stop and answer questions. So again, thanks guys, and I'll be right back.
Thank you.
Okay. Yeah, give you your materials here.
Thank you.
Good morning.
Good morning.
Good
Are we
morning.
having fun yet? I hope so. What I'm going to do is bring in the detail parts. First of all, there's one form that we use all the sub schedules point to it. It's like they say, all roads lead to Rome. All the schedules that we'll be preparing for court accounting aim towards this particular form. It's called GC 400. G is guardian and conservatorship, 400, and then parens the word sum. And if your book has page numbers in the lower left, it's page 22. And it starts out, says summary of account, and then the next biggest word on it is charges. Let me bring one up. I have to get through the petition first. There we go.
Can I ask, who is the probate examiner in Contra Costa County?
Okay, the term probate examiner is used in a probate court. They're so busy that the clerks really review all the inbound paper for the judge before the judge gets it. And you might consider them clerks in the probate department. Some courts will not allow you to talk with them directly. In Contra Costa, you can. In Alameda, you cannot talk to them directly. But they're basically the clerks in the court, the probate division. And the other thing they're really invaluable, you turn your papers in, your account, and it's like having a school teacher grade your papers. I mean, they don't give you a report card or anything, but a couple weeks before your hearing, you need to go online and look for something online related to your case number on the day of your hearing that says probate exam, it says tentative ruling. So in other words, they're listing the things that you need to provide the court. We just got one the other day where somebody needed a statement of gains and losses on securities. And if you don't provide that before the hearing, the judge, that's what your ruling is going to be. You got to get this gains or loss on the sale of securities. So the tentative rulings are invaluable. And, you know, like they say, don't leave home without your credit card or something. Don't go to your hearing without checking the tentative rulings for your case, because if you ignore that process, that's the answer you're going to get, and you're not going to get your approval on your hearing, and that'll push you out, some courts, up to 3 months. So anyway,
I may be filing something in Contra Costa County fairly soon. Are you able to tell me who the probate examiner is and name and phone number?
I can't stop the meeting to do that. There's Erica and Linda and Sue Long, but you can look that one up. I can't look it up at the moment.
Yeah, okay.
So let's get back to the summary of charges. This is the form that you will, everything runs through it. And if you've had other kinds of accounting courses, and like when I went through accounting school, they didn't teach anything about court accounting. It's completely different than double entry accounting and for businesses and everything else. Let's get the headings set up. They're all the same for each of your forms. And this is a current account. So you get your letters. Then within 90 days, Tammara was telling you about doing the inventory and appraisal, the snapshot of all the assets when you started, and that's what you're responsible for. And if anything's missing, you're personally liable. And then after 1 year after your letters are issued, then you have to do your first account. So here, person was appointed on March 8th, went through March 7th, the following year. And we're labeling this the first time we've gone around with this accounting. So that's that. And for those of you who end up getting a temporary guardianship or conservatorship, you must start your accounting as of the date of your temporary, not of your actual letters.
Oh, excuse me, wait, say that again?
Okay, yeah, what happens is oftentimes when you're working with a guardianship or conservatorship, you get a temporary letters that says, okay, you need to do these certain things, and then we'll give you the permanent, come back in a couple months. or whatever it says. And all I mentioned was your accounting starts when you get your temporary letters, because that's when you have access to all the funds that the
And that's
ward,
the letter.
so your accounting starts at that time. That's what I'm saying. Not when you get your actual letters.
Should the referee been on the temporary or no?
I don't believe so. I can't answer that. I've only seen them on the actual letters, not the temporary, but I don't have an answer to that. So let me give you an overview of the summary of account, because this is pivotal. We're going to keep flipping back here. If you've got a paper printout, you might dog ear the page, because we're going to be flipping back all the time. So an overview at 35,000 feet of this form. We have assets at the beginning of the period, cash and non-cash. Then we go through, and the term charges, they couldn't have come up with more unusual words, you know, like Old English or something. All law has to use convoluted terms. They just can't talk normal. So charges means everything that you're responsible for and everything that came in. So it's just an unusual word. I would call it assets or income or something, but they don't. And then on the middle of the page here, we have credits. And what those are disbursements. I would call them disbursements or expenses or something, but they've got to use a weird word. And not only that, to make it worse, the term credit is here the opposite of accounting principles, because disbursements are debits in real accounting and they're credits here. Anyway, you got to be careful if you're guardianship conservator or trustee in a court accounting that you don't hire a firm that does not know how to do it right. Just because a person's a CPA does not mean they know how to do court accounting. And if you get a firm that does it wrong, court kicks it out and you have to get another one, you will have to pay for that second project yourself out of your own pocket. So court accounting is not generally accepted. Anyway, so charges, assets, credits going out, and then we're just doing a quick overview, the ending assets, and the goal of this whole exercise and the big thrill out of doing the court accounting, if there is one, is when the total charges equals the total credits. And at that point, you balance. And unfortunately, the courts are kind of anal retentive in the fact that they make you account for every penny. So 57 cents, okay. And when I went to accounting school, if we were off by 2 cents, hell, we just tape it on the page and say that's good enough, you know? But not for the court accounting. You have to.
Let me in, sorry, so I can see comments.
Sure. Where do you want to stand? Behind me?
No, accept my. Sorry, guys.
We're trying to get the questions up and visible.
There we go. Thank you.
Okay. And because on my screen, I don't see them yet. Anyway, so I'm going to cover in detail this GC 400 sub. And the forms, we have samples in the packet. A lot of law libraries have forms also. You can get these from the internet, and I point down here in the lower left, Judicial Council is like the board of directors for the California Supreme Court. This is the form number. You can do a Google search and bring up the PDF and get all the forms. There's about 37 different forms, but just get the ones you need. And it also says here, while I'm in this section, mandatory. The courts don't have a choice. For all accounting, they're supposed to have this: probate, guardianships, conservatorships. And in addition, if you They have a little bit more latitude, but if you're a trustee on a trust turning in your accounting for approval, technically you're supposed to use this too, but a lot of times the courts are lenient with that. So you need to memorize this form, and let me go through the different parts. Starting out with cash. We've already been there, done that. And if you recall, that was a major part of our inventory and appraisal. The cash, you don't have to do anything yourself. That was back here, if I can get it to change. So we had the cash calculated, and then we sent the real property or bigger stuff out to the probate referee to get an appraisal on that. A probate referee, there's about 5 per county usually. And what they are, they're private business people. They may be real estate agents. They may be paralegals. They may be a lot of different backgrounds, and they're independent business people. And the nice thing about them is they have to appraise everything, excuse me, unless it's a specialty item, like a coin collection, a stamp collection, a Rolls-Royce antique car collection. Some of the things you end up having to pay for another appraiser. And their fee is fairly reasonable. I think it's 1/10 of 1% of the assets they appraise. So lines 1A, 1B, we get from the inventory and appraisal. Been there, done that. There's a total. So we go down this list, and what we see in our practice is.
Excuse me. Is this information that you're referring to? Is this in the handbook for the conservatorship?
Yes, ma'am. What we did is all of our material for teaching this class came out of the handbook for guardians and conservators. So you will see every screen that we have here came out of that book, because that was approved by the Judicial Council. And yes, in addition to a lot more, for guardians and conservators, that book is invaluable. It's about, I don't know, 170 some odd pages. It would be worth it to read the whole thing. I would recommend you do that if you're a guardian or a conservator. For probate, not so much. But there's a lot of good things in there for probate.
In the handbook, which may be found on page 198 in the handbook for conservators.
I don't know what 198. She found what? Found this form?
You'll find that summary.
Okay. Yeah. As I said, all of the forms in our class came from that book, with few exceptions. So.
You know what? My packet only has the D28 and stuff like that. I don't have the 198.
Okay, we're looking at a GC 400 sum.
It's page 198.
Okay, someone says it's on page 198 in the handbook. I tried to put Bates numbers, but not everybody has them, 21. And then if you don't have that number, then here we have D12 from the handbook. And I believe what that means is if you go to the Appendix D in the Guardianship Conservator Handbook and go to Appendix D, page 12, then we'll all be on the same page.
Is that the summary of account standard and simplified accounts?
Yes, ma'am. That's the one we're doing. And
So
let's take some definition.
Did you guys start off on?
It was muffled. You got to talk directly into the microphone. Your sentence is not coming out clear.
Oh, okay. I was asking, did you guys start off with sample checkbook register?
No, we did not.
Okay.
That's this page referring to the check register. There's not a lot to it. Most people have used a pocket check register, and this is okay to use. And you need to list details. And all the time you're listing details, you need to say who the vendor was, what you bought, and how does it relate to the ward? How does it benefit them? And so that it doesn't look like you're buying your own, dinner and entertainment to the movie or something, which is not allowed. So we're going back to the charges. And this particular item, additional property received during the count. That's if all of a sudden you found out, gee, I didn't know there was another mutual fund. And when you're taking over as guardian conservator, take over the mail also. And if you can get their online accounts for email, and the bank automatic payments, because there may be things in there that you don't know exist. And some people will get a forwarding address, say if the person moved to a home, and that way they get all the mail in the future, and you look for liabilities and assets and things as time goes on. So you might find new assets. Receipts during accounting period, we're going to cover that in detail. And it can be income or other items. This is not taxable. That's not the purpose of court accounting. And when we do the fiduciary tax returns, that's IRS Form 1041 and California FTB Form 541, this accounting is helpful, but it's not tax accounting, and there's major differences between the two different systems. So gains during period, we'll cover that, and other charges, so kind of like a miscellaneous, things that didn't fit other categories, and net income from trade or business. So if the ward owns a business, sole proprietor, LLC, partnership, all you have to do, fortunately, for the court accounting for the ward is put the net income here that the accountant for the company provided, and you don't have to do all that paperwork. Okay, then we add up the total charges, and basically we're going to show you how each of these pages. So Schedule A is going to have several pages. B may have one. Schedule C, normally disbursements, you'll have several pages. Those are just general operating expenses. Losses on account, period. If you had stocks and bonds, that may end up being a loss. And getting back to a point on the inventory and appraisal, it's recommended that you give every asset an asset number. So you start with the cash, and this is not bank account number or anything else. So however your inventory and appraisal looks that you provided, and the sheet that you got back from the probate referee, give each of the assets a number and follow that number all the way through. Because like this is back on the inventory appraisal. So if you sold a bond, you go back to what it was on your inventory and appraisal and then do the sale from that. So, and that's just a nice thing because it helps the probate examiners track what assets were sold. So, all right, so we have a little delay here on the screen versus when I'm clicking it. Okay, distributions to ward or conservatee. This would be like if the person had developmentally disabled, but they had an allowance of $400 a month where they could spend it on whatever they want, go to Starbucks, whatever. Would go here. Other credits or miscellaneous types of disbursements that may not fit in another category. Here we're back at the line 12, net loss from a trade or business. It's the other flip side of line 6 above for business. And then we have schedule assets on hand at the end of the period. Okay. And essentially what we have is that's the equivalent of an initial inventory and appraisal, but at the end of the account period. So our account in this example goes to March 7th. So when you talk about what assets are on hand, you're talking about March 7th. And that's the ending balance at all of the, for all the assets. And these assets, let's say somebody bought a house in Hillsborough, for example, they paid $50,000 for it 30 years ago. And when you took over as trustee, guardian, or conservator, it was worth $3 million. Okay, the fair market value goes on your inventory and appraisal. So it doesn't matter what the ward paid for it. You're responsible for $3 million. And if you sold it at 2.5, that's what you use for gain or loss for this reporting. It's not tax reporting, as I say. And so you go through the same drill at the end of the account period. It's equivalent to another inventory and appraisal. And I know from experience, the first thing the probate examiners who are looking at the case for the judge, these numbers must balance. Okay.
Excuse me, can I ask, cash assets, is that the amount that's that's in your bank accounts at the end of the accounting period? Is that what that?
Yes, yes, that is. But we're going to show you the form. It's down a ways and we're not quite there yet, but that's what it is. Yes. And people might have, 4 or 5 accounts, things like that. Another word to the wise, we usually file our papers in person, but when you're dealing with court clerks or probate examiners, you are going to be on your best behavior. Do not ever give the probate examiners, clerks, a bad time in court. You do so at your peril because they're evaluating all your things and you don't want any anything other than a happy face as you're working with them. And our probate examiners here in Contra Costa County, Superior Court Martinez, they have told me officially that when you do your accounting, they will look at it. If you ask them, would you look at it as to format? They're afraid to say that I approve it because then that's a whole different thing. They have to do a lot of work to get there. But it's a kind of like letting a teacher look at your essays before you're done and let you go back and fix them. And that's before you file. So I think it's a benefit to have them take a look at it and see your format. So some of the things of format that are ironic to me, don't ever show your pages in landscape view. They can't read landscape view for some reason, everybody else can, but not in the court. Another thing is they want at least 12-point type. If you go in there with 8 to 10-point type, they'll kick it right out. So those are little formatting things. So anyway, we've gone through these parts and we'll come back and forth to the GC 400 again often. I'm going to go on to the next page, which I hope you have in your packet. I don't believe this one is in sequence in the book, the Guardian Conservatorship book. I don't actually recall where I first found out about this form, but do you have this one?
I wanted to ask, so in my case, which is a probate matter, not a conservatorship, I downloaded a Word doc summary of account form to use because I didn't think that the the GC 400 could be used because it refers to conservatorships and guardianships. See what I'm asking? So
I do. No, I know the answer, and I'll answer it. Okay. This form, if you look at it, it's required for guardianship, probate, and conservatorships. And the form doesn't even show up here. They're more flexible on, well, not really. Here it's part. I was thinking of trust. It says probate, so it's required for probate. And yes, there are spreadsheets. We make one available. It's in the material for a modest fee. But when you're doing a probate, you go guardianship, conservator. Nope, not yet. You just put a box up here that say probate. Use this form is my suggestion. Don't try the spreadsheet on this form because it's required. And some probate examiners, if it looks nice and pretty, they'll take them without the judicial counsel form. Don't try it. What's the advantage? I don't see an advantage. And sometimes they'll take the subschedules as spreadsheets. And like I say, we have a spreadsheet that we make available. But this is your cap sheet. I wouldn't play with this one. You want it to look pristine and nothing unusual, balanced, and you want all your documents approved. So I hope that answered the question. Schedule A's and C's, I'll explain how this works, but we have all these subschedules, and you may have quite a few different schedules that all filter into the 400 sum, GC 400 sum, but there's no place to accumulate subtotals. And that's what I like this form for. And I think it's very useful to be able to walk backwards from, okay, how did you get the total for Schedule A? Well, in your Schedule A's, you may have 27 pages and different parts, and there's nothing that summarizes it, where if you use the GC 400 AC, it gives you all the different parts of the Schedule A, and your total comes forward. So for me as an accountant, it's a no-brainer. You need this, to me, because how can I check somebody else's work unless they're going to make me or the probate examiners go back through all the schedules. Now it says, do not file with accounting. Well, I haven't heard of anybody yet getting shot by the probate examiners for including this form. I would, and I definitely use it. So now we're going to get into the details of the subschedules that will feed back to the GC 400 sum. First of all, we've got receipts, dividends. Put your masthead up here, probate if it is, whatever it is. Okay, so you have to list every dividend. This is a dividend, well, yeah, cash dividends. The probate examiners will not accept if you take how many dividends were received for the quarter. They'll kick it right out. You have to show every little transaction, every 3 cents of interest, all that little stuff, every one of them. And you're going to turn in your original bank statements and investment statements, so they will cross-check that. Another thing it's a little special or pet peeve of mine is 6-digit dates. Get in the habit of 6-digit dates for everything you do in court accounting and any type of accounting, actually. I went to an IRS audit one time with a client, and he was a salesman getting audited for his travel and entertainment. So he brought in a pile of receipts for entertainment costs. All of them were in 4-digit dates. None of the years were showing. How do you know what, I mean, I kind of thought maybe he just collected them all the time, and every time he got audited, he brought the same ones, but don't do that. You know, it's not, you're responsible for every penny in your accounting. Okay, so we've listed all the dividends from the, in this case, stockbrokers report, Charles Schwab, Merrill Lynch, whoever. And we get down here to the total for this page for dividends. If you've got multiple accounts, do Safeguard first, do Charles Schwab next, do Merrill Lynch after that, keep them by vendor so that probate examiners can cross-reference your source documents. And we get the total of this page. And we have a little box here.
Is this for cash only? Cash only?
This is receipts of dividends.
Dividend, okay.
Yeah,
If
so
you have
I mean, other types of reports, we've got interest separated, we've got pension separated. So we're gonna go down the 31 flavors of types of income and expense.
Excuse me, if you get dividends from several different entities, do you need to do a separate page for each entity? Would that be better?
That's your choice. All I said was have your heading and then all of them for that account. If you decide to have one per vendor, you're going to make your pages a lot thicker when you get done. I don't think I would do that. Just the fact that if you're doing a year and they're getting monthly dividends, you got 12 transactions. Okay, so I can get 12 here, I can get another 12, and then maybe I'd go on to the next page. I just don't want to get the probate examiners irritated because they have to do a lot of page flipping that might be unnecessary. Okay, so when you get to the total, what we have is there's a box that says subtotal. And if you check that box, what that means is that there are more Schedule A's. So this is only the first of 6. So they're going to be looking for another form here pretty soon.
I'm looking at the form. It says on mine, I found it. It says GC 400 AC, and then it says when you get the paper, it says Schedules A and C, receipts and distribution worksheet. But on the side where you're reading at, where it says dividends, it says GC 400 form. That's the form number, I guess, for the receipt category dividends. Is that how it is presented?
Yeah.
I know you said
what we're talking about on the formatting is this is a total of the dividends page. And it is all of the forms, just court weirdness, are GC 400 somethings. This one happens to be the A1. A1 means receipts for dividends. And in your question, which is a good one, that this subtotal, we're done with the dividends now, let's say, and then we go to the summary sheet, the AC, 400 AC, and yes, this is where the dividends would go. And you can do that all the way down.
Do you mean, I'm sorry, do you mean on form GC 400A1? That's the form number for dividends.
The dividends, yes. And we're going to go through all of them. This one's for interest, happens to be called A2.
Okay.
So when you
all they do is they add additional letters after the GC. This one for pensions is A3. So that's really the distinction that you know you're on a different, in this case, type of receipt.
So that you only have safeguard investment, and then you have dates, and then you have the amount. So what is that? Is that they're getting that amount every month?
Okay, yeah, this is, I took it off the safeguard investment account statement. Right. And as I went down, I looked at the cash dividends. Okay, so each month it was $352. I didn't have to write anything in here because it's still the same account. I would have put the last 4 digits of the account number always. But that's all you need to show is the monthly amount, not a quarterly total. So does that answer the question?
So you did it from from April to March. That's how much money he made during that time.
That is correct.
Okay.
During your account period. So you're only including money during your account period.
And how do I know my amount period? How do I know my amount period?
Okay, your account period is the time from when you were appointed to the time when you're first, in the example, we're saying you get appointed as conservator on March 8th. Then you do your inventory and appraisal. Now the world starts to turn and income and expense and things start happening financially because you're guardian of the estate. And for those of you who don't know, a lot of people will be guardian of the person and they can't touch the funds. And then you can have the same person or a different person be guardian of the estate. And that's this whole ballpark. So it goes through the end of the first year after you got your letters.
So then you don't have to do this within 90 days.
The only thing that is 90 days is the inventory and appraisal. That's why you have to get started on that right away. You've only got 90 days, and sometimes it takes the probate referees 3 weeks or something to come up with a value of a property, for example.
And did you say you
inventory
attached? Sorry, you attached the statements, is that right?
The bank statements, yes.
Okay.
You must attach original bank statements. You can keep copies, but they won't process it without original statements.
So then when do you have to turn this part? Schedule A, all this other. When do you have to turn this in?
Okay. When you file your, okay, so you get your letters.
Right.
We don't have an example of letters, but we'll go back here. So you got your letters, let's say March 8th. And right now, you know you got a 90-day deadline for the inventory and appraisal. And right now, you know that you're going to have to do an accounting by March 7th next year.
Oh, so you have a whole year to do that.
The first account is done at the end of your first year of your appointment as guardian, conservator, or probate executor, personal representative.
How much time do you typically have at the end of the accounting period to file your accounting? Once that 2015 date comes up, how much time do you have in which you must file the accounting?
That's a good question. I don't know the answer. Usually what happens though is you've been given a court date. So when you turn in your inventory and appraisal, they will say, okay, by March, April, May of next year, you have a hearing date to turn in your accounting.
Okay.
So it could be 60 to 90 days before you actually have to file the accounting.
It could be 60 or 90 days after the end of the year, yes.
Yes, at the end of the accounting period.
After the end, yeah. First you got to get to the end, and then the hearing would be after. And just the protocol for the accounting is you do one accounting at the end of the first year. Then you do your accounting and turn it in every 2 years after that point.
Okay.
So it ends up being the odd years, 1, 3, 5, 7, 9. Each time you have to do an accounting. For trusts, you can do the same thing. You can turn them in, and a lot of times people will turn in accountings for trusts to have the judge sign off that this judge thinks it's correct, and it cuts off liabilities for beneficiaries suing the trustee for alleged misconduct. And so it's a voluntary procedure for trusts. So now let's move on. We're on interest. We have the name of the bank and each individual interest transaction. And we're still on a GC 400A series. And it's also a subtotal. And as we move through these, this is our second of the A series, and we've got 4 more to go, it lets them know. So we're not done yet. Now
How do
we
you
go into
handle-
pensions,
How do
annuities.
you handle if people in the family are asking for copies of all the financial documents? Now, I'm new to this process. I'm a temporary conservatorship, and I have various family members asking for, like, he just got awarded disability, for the receipt of the disability letter and everything. But it's not that I'm not transparent. I've told them verbally everything on the phone, but handing documents with account numbers and all that makes me nervous. How does one go about it?
Here's a suggestion. I know the question
because
because
it's going to be filed with the court. All the
here's what I suggest you do. For all fiduciaries, fiduciary means you're taking care of someone else's money. With all fiduciaries, I suggest with beneficiaries and family members who would be a beneficiary if the person passed away, that you give financial information and communications on what's happening. And you do that often. And the more information that the beneficiaries or the family members have, the less you're likely to get sued, because when the beneficiaries don't hear anything, they always assume that the person took off with all the money. I don't know why, but that's what they assume. So one suggestion, and it really do, I am suggesting you give them communications on the person's care, their person's location, and they really have a right to know. And if they sued you, they could get it from the court, would order it. One thing you might do, you brought up the question of not wanting to give out the bank accounts. One idea you might consider is using Google Drive, scan all of the bank statements and the stockbroker statements, use a highlighter, a dark highlighter, to block out the account numbers except the last 4 digits, and put all of the bank statements, the investment statements, and everything on Google Drive, and then give everyone who has a need to know, or they're an heir to the person if they passed away, they can go on and look anytime they want.
Well,
and
John
so
is very
you don't
much
have to feel
alive,
that.
and his John is very
Oh.
much alive. We're bringing him home. He's very, very sick. But these are like siblings that don't, wouldn't be heirs to anything. They're just, I have a group chat where I update all his physical stuff.
Okay,
Once I got
siblings.
awarded disability, I've been very transparent. But they want documents, like they want the financial papers, and they're not really party to that. I would much rather refer them to go to look at my inventory, and because
I understand the
there's been
question,
some
and that's,
family members that have
you
taken
can
money
deal with
before,
that
and
however you want. I would suggest that you give it to them. And my reason is you blocked out the account, so there can't be any, any changes or something like that on unauthorized transactions. But what's the downside? A sibling is a beneficiary, a potential beneficiary. If somebody dies without a will, everybody who would inherit is an heir at California law, and siblings are. So you would end up having to give them information if the person passed. And all I'm trying to do when I'm advising clients is give the potential heirs data so they can rest assured that you're doing the right thing. It's up to you. But you do what you want. I don't think there's a requirement. I'm just trying to reduce litigation. Okay.
Would you put would you put the payment for the receipt payment on 400A2 or A3 for insurance policies?
I'm not there yet. I'm going to go through them in sequence. We're done.
Okay.
This is all inbound funds I'm going to do first. So this is pensions. And in this case, we have a teacher's pension. We listed all of them. And we have a total. It is a subtotal. We're not done yet. We're on 3 of 6. And we keep moving. And here's rental property. Okay. On rental property, you would list the name of the property and the address and the monthly rent. Sometimes we'll put in a tenant's last name. And if you ever rent to family members of yours or the wards, list it, and then you're supposed to get fair market value for the rent. I would also include what kind of property is it? 121 View Place, is that a single family home? Is it a shopping center? Is it a 100-unit apartment building? I mean, let the probate examiners know what they're dealing with.
Do you mind, what if you spend money on painting the apartment? And let's say I spend $2,000 painting.
Disbursements.
Do I mind it?
No.
No, okay.
We're only doing the income at this time, but you bring up a good point. And the point, my terminology is called netting, N-E-T-I-N-G, netting. You don't net numbers. Okay. So let's say the tenant on the March 1 said, I'm going to paint the porch and I'll charge you $500 and I'll do a good job. And so the tenant turns in $2,000 and the 500's not there now. No, I don't net. You have to show what the value of the rent was. And then when we get to expenses, you will show a barter expense or something of that nature with a receipt signed off and things.
Okay.
But
Is there a minimum?
It looks
there a
like
minimum that you can charge for rent? With that you can pay for rent for what did you say, a base standard?
I'm trying to understand the question, but you want to charge fair market value rent. You can't charge discount.
What's fair market value rent?
What is the rent in the neighborhood? Say you have a townhouse, condo on a street that has all kinds of apartments and condos, and they're all renting for $3,000 a month. That's what you need to charge. Sometimes, you can back it up with Zillow or Redfin or some of the others. You can hire a real estate broker to give you an opinion. But you need to.
It looks like they didn't start collecting rent until August, even though the conservatorship started in March. So for the time.
And this is not, understand,
this was the problem.
It could have been that the ward was moved from their house and the house was rented.
She was
Maybe
still
they moved in.
Still living in her own home maybe, and then she went to another place. And so they rented out the property.
Yeah. Okay. You could, if that occurred, the ward was in that house, or the ward moved out and it took 2 months to get the house fixed up in rentable condition. And you could put, a description of why it started in August.
Okay, that was where my question was, is do you need to account for those 3 to 4 months during that conservatorship where there was no rent?
What you're responsible for is to accurately report every nickel of money that you received.
Okay.
If you didn't receive it, they don't, you know, it might be good to disclose it, but it's not required to be put here. So we're getting subtotal, we've got rent, we're on Schedule A, 4 of 6. And so now we've got Social Security, and we gave this class to probate examiners, and the first thing they noticed was this. They go, you can't do that. What the person did on this account, for example, they added 3 months at a time and put in one number. Can't do it. Every transaction has to be shown separate. And in this case, there's a footnote that says, this is the amount of cash we got. That's all I'm responsible for. But I'm letting you know that Social Security kept $104. I'm not netting because you have gross less an expense. You have no control over that amount they retained. Only cash that came in was what is reflected. Okay. So.
They break it down each month then?
I did not hear the question.
Should they have broken that down for each month? April, May?
It's not per month, it's per transaction. If there's 2 transactions in a month, 4 transactions in a month, you show them all. And what they did was they totaled up for a quarter. It may have been once a month, but I think the best answer is every transaction shows. Now, here we have other receipts, and it's miscellaneous. So if it didn't fit those others, okay, fine. State tax refund, refund for prescriptions, different things. Just list those. And now you'll see we have, it is a subtotal. Don't ever accumulate accumulate your numbers. You'll be so far off. So if you took all the Schedule A's that we looked at so far and took the total of page 1 and then added that to page 2 and added that to page 3 all the way through 6, you'd have a huge number here. You'd be so far off. You don't accumulate. This is A6 of 6. Now we're done with the receipts section. And this is a break point in the accounting where I would anyway, then go to the 400 AC for a summary. So, okay, we got dividends, this, rents, this, Social Security's that. And then I would total it, all the Schedule A's here. And the next stop is a GC 400 sum where we list the total for all of them. Is that clear to everybody? Everything leads back to this GC 400 sum.
Rex, I have a question.
Yeah.
If I'm in a situation right now where my niece has been living in my mother's home rent-free for 5 years. She did not attain the power of attorney properly. And now I have temporary conservatorship over her. My mother is supposed to be back into her home, but my niece isn't allowing her back in her home. I say that to say, okay, do we put a debit? Because it's definitely not a credit, and because she's basically a guest in the house. So therefore, how would I, if I had to fill this paperwork out, how would I do that? Or where, on what line would I do that? Because it would be a negative for my mother.
Okay.
Until I can get her out.
Okay. Okay. First of all, you have a responsibility as a fiduciary to get maximum value out of all assets and to go after assets that are not, like, we've got one where there's a carryback note that the client owned and they're not paying for it in Idaho. Well, the trustee or guardian has to go after that money to try to collect it. So in this case, what you have is a freeloader, and as a fiduciary, I would issue them a notice of proposed action that in 30 days they're going to pay rent. And if they don't, we're going to start eviction. And then, so you give them notice of proposed action first, and then when they don't pay, you get a fair market value rent. Then after they don't pay, you do a 3-day notice to pay rent or quit. And, you know, whether it's a 60-day or whatever notice required by current eviction law, and then you would start an eviction.
Right. Okay.
So that, but in terms of accounting, you need to get disclosure out there to protect you from liability.
Right.
In that you did not authorize that person in the house.
Right. Right.
You might also consider, well, talk to them first, obviously, and you might also consider a police report.
Yes, I've done that. We've had to take, you know, we're kind of beyond that, because even doing a rental agreement puts them into renter's rights, whereas they've been living in my mother's home.
I understand, but I can't take more time on a problem.
I got it.
But we've done evictions on squatters before.
Okay.
And that's what you have. So
Sure.
It's not part of this class. So
thank you.
Now, after the Schedule A's, we're going to start the B series of gains. In this case, we show the property. We're way behind on the class material. So our carry value appraisal when we got this assignment, the letters, was 230. Sale price was 250, and we're showing a gain here of 19. That's the way it's done. You notice there's no closing costs. Those will come in the expense section. So here's disbursements for long-term care. List each one of them. And if there's anything unusual, one of the probate examiners gave me an example of, let's say you bought 75 sheets for the ward. They're going to say, what are you doing? What are you buying 75 sheets? Well, when you put that expense in the expenses, add a note to say the ward is incontinent. And so that gives a justification. How does it benefit the ward? Okay, so now we're into general administrative expenses.
You
just
talked
list
about
those.
fair market value. How do you figure out that for stuff like rent and food if you don't know how much to pay another individual for that? Like,
okay, look up about real estate appraisal. Look on Zillow and Redfin. Look on Craigslist. Look at, like, say it's a 2-bedroom, 1-bath in that neighborhood, and start making a list of all of them and try to come up with a comparable quality. And
what if it's
you need
like rent for somebody? It's kind of confusing. So I'm bringing a loved one home here to my home. I feel uncomfortable collecting rent, but at the same time, I'm converting my living room into a bedroom because I don't even have a place to receive him. And I don't want him to go into convalescent care.
That's beyond accounting that's already happened, and I don't have time to go into it, but you may have a right to rent, charge rent, and if you don't pay yourself rent, the guardian conservatorship and the attorney for the guardian conservatorship or trustee cannot get paid at all other than reimbursed expense until the end of the accounting and it's approved by the court. So if you think there should be a rent, put it on the books that you think it's due, ask for reimbursement when you turn in your
I'm
accounting.
more worried about food because he has to eat and have special shakes and all this stuff, like
Keep track
purchasing
of it.
it and then getting
Keep
reimbursed.
track.
I can't quite. Okay.
Okay.
So would that be, would you put that reimbursement on 400A6 other receipts?
It's not a receipt. I would put it on the, in the petition that you give to the court, that's petition or report or cover letter. Where you put, Tammara hasn't gotten to the petition yet, but I need to get through this so she can teach you what to do on the cover letter. So if we could hold the questions for a little while. We have disbursements, living expenses, actual disbursements, and then medical expenses, just list them. Property sale. We had a sale of real estate previously, and here's where the expenses for the transaction go, and also the payoff of a mortgage. And this was a commission on selling property on consignment. Now the rental property expense, and I would have each property separate list of expenses. One time we saw one submitted that was like a Schedule E on a tax return where it was income and expense by property, and that's not court format and they wouldn't take it. But keep your rental expenses per transaction and keep them separate by property. Disbursement others, IRS, tax repair, losses on sales. Here we have a car that was appraised at $3,100 when we took over, sold it for $3,000, so we ended up having a loss. Now we're getting to the end of the ending inventory and appraisal, but I want to go back to the GC 400 first. So we have brought in all our schedules. So all the income schedules and the credit schedules. Now you'll see some of these, if you have a unique item, or you decide to use one, go ahead and give it a distinction, but I would switch to numbers, not letters. So Schedule 1, Schedule 2, Schedule 3, Schedule 4. Because when I first started working on this form, I go, oh, I'm going to use alpha descriptions and I'm going to pick Schedule E. Well, then I found out there already was a Schedule E. So it's simpler if you just switch to numbers or double letters, A, B, B, C, C. So anyway, we've listed our beginning. We have all the income that came in, receipts. We've posted all the disbursements. Now we're at the value or the carry value at the end of the accounting period. And where was that? Okay, so at the end of accounting period, we've already been through the drill on how to get inventory and appraisal, and the cash is on that cutoff date. You just list what it is, and not the number that shows at the end of the month. You have to reconcile it to the date of the cutoff of the accounting. Now, on the ending non-cash, we do not include the probate referee. Again, we have to use the carry value that we originally received. And what you do over here under estimated market value, you guess, you do the best you can. Tammara, could you do the petition soon?
So I have a question for you. So the rental income, that's really basically is if you have some type of property that you're receiving rent from. Is that correct?
Yes.
That's not
So-
property. That's not anything that you're paying for to live in.
Okay. So rent that you're paying, let me see where I can find that.
It kind of makes it confusing because when it goes into disbursement category, it goes into conservative caregiver expenses, because this is the kind of stuff that would pertain to an individual that receives Social Security versus any type of teacher's pensions or anything like that. So
Okay, so here
here.
okay, hold on. Here's Schedule 400C2. Disbursements, conservatives, residential care. So your rent would go here for the conservative.
Oh, okay, okay.
What you actually paid. So I'm gonna find Tammara and let her take over, because we've got about 20 minutes and we need to teach you how to do the petition or cover letter that accompanies your account.
12:30. About 40 minutes.
Okay.
Hello, I'm back.
Hello.
I've just got a coat on now because Rex likes to work in a freezer, and I freeze to death every day. So I have my little safety coat here keeping me warm, even though it's 100 degrees outside. It's freezing in here. Okay, so we are going
or something that we took this class. Like, how do we verify that we took it? Because I think it's a requirement, correct?
we can send out certificates to anybody who wishes them.
Yeah, just send us a request.
Okay, that would be great. I'd like one. Thank you.
And what
Okay,
is this certificate? I'm sorry, I missed that.
Yeah, I'm sorry. She was asking if there's a certificate of completion or anything that she could receive from us at the end of the class stating that she took the class. And we just say, if you send us an email and let us know you wish a certificate, I can issue one.
Okay, and what's the email that we're sending it to?
It would go to the Rex Crandell, and that's REX CRAN as in Nancy, D as in dog, E as in Edward, L as in Larry, L as in Larry, at astound, ASTOUND.net. I think that information's at the end of the paperwork or the slides that we have here.
So let me make sure that I have this correct. It is REXCRANDELL at ASTOUND.net.
Correct.
Okay, thank you.
Okay, so I'm going to go and complete the last part of this accounting process for you. And so what it is now is you've done the inventory and appraisal. You have completed your accounting, and now you're going to basically complete what's called a petition. And this petition is just stating, you're basically just summarizing your accounting, and you're telling the judge or the court, what do you want them to do with that? So, okay, so we're going to start with how to complete the petition. This same header foot, can you guys see my, one of the things that's really important is this petition that you turn in must, and I'm saying must,
be on pleading paper, and pleading paper means it has these cute little numbers along the side. The pleading paper, blank pleading paper can be found online if you just do a Google search. You'll be able to find pleading paper you can use. I know Microsoft Word has pleading paper templates. So there are many places where you can get the pleading paper. What's really important is just keep in mind that both inventory and appraisal and the petition need to be typed. They cannot be handwritten, but your accounting can. So that part is important. And okay, we'll just continue moving forward. So your top header portion right here is going to be the same header portion that we described on the inventory and appraisal. In this case, we've used an example from an attorney, but if you are completing this yourself and turning it in yourself, this will be your name on line 1. There will be no state bar number. It's just going to be your name, your address, the city, state zip, your phone number, your email address, and you would just state your name and your conservator or your title. You don't, no attorney for, that's left off. You just put your name and conservator, and then you would write the words proper, P-R-O-P-E-R, means you're representing yourself. Okay, typically there's about 2 blank lines, and you will need this centered, and so it'll be Superior Court of California and whatever county you are submitting this to. This case example shows County of Orange, but typically I submit to County of Contra Costa, County of Alameda, County of San Francisco, there, you know, whatever county is, County of Marin, whatever county. You go down 2 more lines, and you're going to state the conservatorship of the person and the estate, or conservatorship of just the person, or conservatorship of just the estate, whatever has been designated to you. Down here, again, is the conservatee. So on the front page of the inventory and appraisal, where we listed the name of the conservatee or the estate of, you just repeat that here. Over on this side, you will put the case number, so the court, or so they know how to file this and what case number to put this to. And in this case, you are stating it is your first account. Now, if you've already done a first account, and this might be your second, your third, your fourth, your fifth, you need to state which account it is. I know there was somebody on here who's already done a few, so please put whatever account it is. But you're gonna state it's the report of the conservator, the report of the guardian, the report of the estate. Just use whatever title is your title. It is a petition for its settlement, so you're asking the court and the judge to approve and give you your wishes. So it's the, in this case, there was a sale of a house in the explanation on the accounting, so it asks for the approval of the sale of the property. You may not have that in your title. And for allowance to pay yourself, and if there's any attorney compensation. And we'll get to, as we go down through the petition, why, where that's important and where you're asking for that. So again, you may not have this exact title in yours, but you will have something similar to it. If you're not asking for attorney compensation, then the words attorney's compensation would not be in here.
Are you supposed to, or are you entitled for compensation for the work you do?
Absolutely. There is local court rules. I know we looked this up yesterday, Leslie. 7.520, I think, is the local court rule that states the fees. It just came out July 1, 2020. The local court rules state the fees. For a non-fiduciary, I do believe, I'm gonna look it up, non-fiduciary rate, which would be someone of your non-professional rate, is $75 an hour. You do get paid for travel time, and there's a whole list, if you go to the local court rule, that lists what fees the attorneys can collect, what fee if you're a fiduciary, can you collect travel time, expenses, and everything else that you can collect for.
What was that local rule number again?
7.52, I believe.
20.
I don't know.
50, yes, might be 50. And I think it's, again, sorry, I looked at it yesterday and it used to be 7.48, but again, it was revised July 1. So there is a new one, and it is 450. Oh, 450, okay, well, the old one started at 7.450. I think the new one is 7. Leslie, was it 7.50 or 52? Oh, she isn't answering. She might have bounced off. Okay, so you'll be able to find if you.
7.5, is it a code you just look up? I don't even know what
Yes,
that
you
is.
would just type it on the computer, local court rule, and if you do 7 point something, then you'll be able to tell what fees are, or it'll find it for you and you'll be able to locate it.
And it's document 7.50.
I believe it's local court rule, section 7 point.
Okay.
But if you request fees, you have to break down each activity that you performed for that $75 an hour.
That's correct, and we'll go through that as soon as we slide down this petition. Okay, so let's complete the form. We'll have the date of the hearing. You will have that date. It will be given to you on what's your next hearing date or when your accounting's due. There will be a time, there will be a department, and then there will be a judge.
So I'm sorry, I don't mean to interrupt. I didn't get the part where it says the allowances for conservators. How does that work?
And we're going to go through that as we slide down the petition. I'll get into much more details. Right now, that was just as part of the title of the document.
All right.
So if you can wait just a tiny bit, I think it's about halfway through, and I'll get into a little bit more details about that.
Sounds good.
Okay. Okay. So I'm going to continue going through the form. We're going to start with you being the petitioner. So in this case, the petitioner, you will put petitioner yourself, and whether you're called a conservator or a guardian, and the title. It could be administrator, it could be executor, it could be special administrator. It just depends on what title. In this case, it's a conservator of the estate of Jeannie, who is the conservatee. And what you're doing is you're presenting for settlement and allowance your first account, current, and you're kind of just repeating this a little bit up here. Report as a conservator, and you respectfully state these important, you're now going to summarize what you did in the accounting. So we're going to start with, though, just keep in mind, and one of the reasons for this is you've got to imagine that, you know, any probate court, a judge goes through, I don't know how many cases a day, many, and he can't remember you from anywhere else. And instead of having him look at your account, most of the time, the judges will look at your case the night before or that morning, and he's got to quickly do a quick summary or in his head so he knows what you're here for. This petition, what it is it's just giving him a snapshot so he does not have to go through your file and see what everything is. So as you'll see as we go through this petition, what you're stating, why it's important, and what kind of the purpose is. So the first thing you're doing is telling him about your appointment. So you say, I, the petitioner, was appointed the conservator of the estate of Jeannie on what date? So the minute he looks at this date, of the letters, he's going to go, oh great, okay, the accounting's going to start, you know, do I have an inventory and appraisal? Well, what's going to happen is the probate examiners will actually go through and do a checklist for the judge that he can see, okay, the inventory and appraisal's been done, now we have the accounting done, it all balances, and now you're giving what you want him to do with that accounting. So in this case, you're telling him, okay, and letters were issued at all times since my appointment. I have been acting as a conservator. So there are some cases that sometimes, like Susie was appointed and then she relinquished or terminated her request for guardianship, so now I took it over, and you know, and you'll state that if that was the case. But in this case, or an example, he's stating the whole time he's acted as the conservator. So basically he's saying, okay, great, so my inventory and appraisal of the estate was returned and filed with the court. Look how many days. Isn't that amazing? 11 days after he got his letters, he was filing the inventory and appraisal. Basically, that tells the judge, okay, he met the 90 days. He doesn't need to look through the stack of papers in the court form or, you know, anything. He goes, okay, right here, I can see it was done in 11 days. That's way too quick, but sure. Our example shows 11 days. Okay, and it's showing the total value of this estate and gives a total value. So basically in this case, you're given the total assets and the total non-assets, and you're telling the judge up front what the total value of the estate is.
Be clear, it was done 2 months after the inventory.
All right, you're right. Sorry, you're right. So 60 days, better than the 90. So again, he automatically knows that here's the total value of the estate. Okay, now you're stating what is the accounting period. So in this case, the accounting period covers this. You'll just repeat what you put on the front page of the accounting report. Or if it's your second one, you will put, yeah, you know, the next, actually the second one would state March 8th, 2013 to March 7th, 2014. I myself don't like this middle of the month endings and beginning, because to me it's so difficult, especially if the bank statements are run on a monthly basis that end at the end of the month, that I've got to try and figure out a stop date. So typically myself, I put on my first accounting that it'll run March 8th, and then I'll run it till the end of the month. So this would include till March 30th, 2013. So my next one, I can start on the 1st and end at a different date, but that's up to you whether, and your courts with it.
The examiners don't give you a problem with that?
I have not had one, no. If it is, I typically explain that the bank statements don't end on that date. And a lot of times, depending on how the bank statements come, you don't know what the ending balance was on exactly the 7th or something like that. So I like to end it at the, you know, I'm almost finished with one right now that it ends like on February 26th. I'm like, there's 2 days left in the month. Really, is that going to make a difference? So I actually ended it on the 28th so I could get through the whole month and not just minus 2 days, just in case there was some transactions going on in there. So anyway, you're telling the court the charges and credits. They got that wording from the accounting worksheet. So the conservator is chargeable and is entitled to the credits. And you would just repeat this kind of summary. Number 5 states that you have, sorry, I'm catching up with my own notes. During the account period, all cash has been invested and maintained in an interest-bearing account. And I apologize, I didn't hear Rex talk about this, but if he did not mention that the minute you take hold of the person's account, you must verify and make sure they are in interest-bearing accounts. I will tell you, we've had a case before where the conservator did not put the monies or make sure the money was in an interest-bearing account. Several years went by, the conservator passed away, and the heirs of the estate went back and charged the conservator for the interest that the money would have earned if it was in an interest-bearing account. And that conservator was responsible and had to pay the heir that interest that they missed out on. So you do state to the court that you have it in an interest-bearing account. The investments are in moderate. They cannot, so you must find out when you take a hold if the stocks and the shares and stuff like that are in a moderate. It can't be an aggressive account. It cannot be anything, it has to just be a moderate investment.
So you can, I'm sorry, you can file one of these petitions just to verify the first account current and report of the conservator and petition for its settlement based on having the property and allowances and all that kind of stuff. Is that correct?
I didn't get the last, I got everything up until the last sentence. Instead of doing what?
Instead of all the other essentials. If a person doesn't have the things that are being presented here, and you just want to kind of bring the first portion of it?
First portion. No, it needs to be a complete, it needs to be a complete accounting. I know for guardianships and I know for conservatorships, they're due every 2 years after the first one. And so, no, it should be a complete, it shouldn't be, the only thing that will be different about it is if you don't have these examples, you won't include them. But so far up to number 5, which we are, you would include all of that every single time you write a petition.
You're saying you must have all the schedules and all and inventory and the summary and account all be there before you do this petition.
That's correct.
Okay.
Okay, so I'm gonna keep.
One through 5 is mandatory on your petition.
Correct. Okay, so number 6 says the statement of liabilities. Basically, you're just telling the court if there's any liens on the assets or anybody who's filing judgments or anything that you know about that has taken place after your first day when you found and filed your inventory and appraisal. Most of the time that would be a no, and you'd be happy with that, but that's still a statement of liabilities that you will state in every petition.
So this petition is a 2-year petition.
This petition is the document we're on right now.
Okay.
That needs to be filed with the accounting. Basically, so you do the inventory and appraisal only one time. Then from then on, you do the accounting and a petition. They go together. You must file them together. When you just file an accounting, you're not asking the court to do anything with it. Do you want them to approve it? Do you want them to throw it away? Do you want them to stomp on it? What do you want them to do? This petition is telling them what you want them to do with it. Also, what's important about the petition is once you get this signed by the judge, now there went your liability purposes. Because you've had it approved by the judge, no one can come back and say anything about your accounting like you were missing money or something like that. Once the judge approves this accounting, you're good. That means he has stated, I believe you, I accept what you say, this is final. Okay, so number 7, the reason why this is here is because in the accounting that Rex gave, there was a sale of an automobile. But if you do not have a sale of an automobile, you won't put this in. So of course, your number 7 could state something completely different than what mine does. But this gives you an example of what to say. This gives you an example of what to say if you did have a sale of automobile. So in this case, it was the conservator sold the conservatee's automobile. It was listed in the inventory and appraisal on attachment number 2, line number 7. It was sold for a loss, which is also shown on Schedule D. The conservator requests that the court confirm and approve the sale of that property. Once the court approves, so say for instance, you sold it and then later on, several years later, one of the grandsons come along and he's an heir and he says, my grandpa promised me that car. Well, he can't come back and sue you for selling it because the court has approved it. Now that does not mean if you know that the car was for the grandson and you really know that, you've heard that from the conservatee and they're competent in making that decision, then you cannot go off and sell the car just because you want to. Okay, so we're getting down the sale of furniture. Again, in our example, we had, there was furniture at the vacation home that decided to sell. They were selling the vacation home, so what are you going to do with the furniture? So in this case, you'll see that they state there was sale of furniture. Again, you're saying how much, what was the appraised value, but I couldn't get that much for it, and here's why. So you're just providing information to the judge on what you did.
So if the conservatee is living in his own home, then you don't put anything about sale of furniture or anything like that.
Oh, absolutely not. Yeah, that's not up to you. One of the other things that is extremely important, which I have a case right now also, is you must keep in mind, there could be other things that you include here, but you must keep in mind that, say for instance, you have a conservatee and something happened to them and you have to worry about, they had a pet. Like, let's say, let me give you two different examples. Let's, in the first example, say they had a horse, okay? So they have a horse, but then they become a conservatee. I can tell you that you can use that pretty much a good judgment that that conservatee will never get out and start horseback riding. One, it'd be a hazard probably to their health and a danger to them. But more than likely, say they were getting old or something, and you just know that they won't be out riding that horse. And you have to kind of make a reasonable, and I'm talking reasonable, determination, like, oh my gosh, by the time I have to buy the bale, the hay, the storage for the horse, or the grooming, the groomsman, a rider, all that expense, and you know that conservatee, say for instance they're put in a rest home or something, they're not going to go out and see that horse, they're not going to have really anything to do with it anymore, then it is your responsibility to preserve the conservatee's assets. And then I would say yes, you would put the horse up for sale, you would get the best for it, so on and so forth. But let me use another example. Say for instance they have a cat. Now please don't judge me, but I'm not really a cat person, I'm very much a dog person. And so if I have a conservatee and they have a cat, one, I think I'd freak out because I don't even know how to take care of a cat. But, and I don't mean that in a real funny way, I'm being honest. I wouldn't even know how to take care of the cat. But just because a cat may not be something I totally adore and love, okay, let's also use like a snake. Maybe they had a snake. You are not allowed, just because that may not be your preference in an animal, you're not allowed to dispose of it, sell it, get rid of it, remove it, whatever. So I have a case going on right now where the conservatee went into a housing facility, and the person now is responsible for taking care of this person's cat. And he was asking me, well, am I allowed to take the cat and get nails clipped and other things that I guess you do with a cat? And I said, as long as it's their cat. And I said, do you ever take that cat to the facility to see the owner, or do you take pictures of the cat and show the conservatee their cat and make them feel comfortable? If the conservatee still asks about that cat, I mean, that is your responsibility, whether you like it or not. I myself would have a horrible hard time, and I'd probably be in a lot of trouble because I somehow, some way probably end up killing the cat, whether I didn't feed it enough or something, but I'm just scared to death because I wouldn't even know how to take care of it. I do some serious research online on how to take care of a cat if that was my case. But again, please remember, you are not allowed just to sell or get rid of the cat just because the conservatee is no longer there, if that is their pet. But the, I'm sorry?
If you're allergic to the cat.
You better pay somebody else to take care of that cat and be able to take pictures and stuff that can show that that cat's still in good standings. Because, and for a lot of people, say for instance, an elder woman or man who's had that cat for 10 years already, and then now he can't take care of the cat because he can't take care of himself. That would be extremely sad for him to know that the cat was just thrown away or tossed out because you didn't feel like you wanted to take care of that animal anymore. That would crush that person, and that you're not allowed to do anything of that nature. Okay, so, but you are authorized to pay out of the estate for the care of that animal. Okay, so that will go back to the end of where we were on our form, where it states whether you have legal capacity to consent to the sale or not. That kind of information is pretty important. Sale of a property, again, you don't have these things, don't put it in here, hon. Your petition may be very small. This is just giving quite a few explanations. So the sale of the vacation home, again, we knew the conservatee was never going to be able to go back to that vacation home, and it would cost you more money to maintain that vacation home that they're not going to get any benefit from. Again, if they're in a home care, leaving that vacation home empty is not going to do them any good. In fact, it's just going to waste their funds. Now, if I use another quick example that it may not be a very good time right this second to sell that vacation home, because maybe it's pouring down rain or there's fires going on right now. That's not, there's, you know, fires, let's say over here in the Bay Area in Vacaville and Fairfield. Right now would not be the time to put a house up for sale on the fire lines because again, you're not going to get, so there may be a case where you keep the vacation home for a small time because you know it would be a disadvantage to the estate. That doesn't mean you can just throw it up. You know, do it wisely. Would you do it with your own goods? No, you wouldn't do it. So don't do it with theirs either. So think responsibly. Okay, in this case, if you believe or not that the bond, again, we're back to this bond. I know it sounds a little nutty or crazy, but now you're telling the judge that you believe that you need an additional bond because now you sold the house, which remember that was non-cash, so that isn't part of a bond money. And now you have cash that's much more than you had before. So you may say, I do need to increase the bond, or if you want to take your own steps and say, I went out and increased my bond for a little bit more. Now, don't be scared of increasing the bonds. Bonds are really not that expensive compared to what they cover. So when you say you're increasing the bond, you could increase the bond quite a bit, and it could only cost you $50 or something like that. So don't be scared about having to increase the bond to cover your cash, because that bond is really going to cover your butt in the end if something should have happened and money walks away. So That's all you're stating down here. And right now you're stating at the very end that you believe now that you increase the bond, that your bond is sufficient for the estate. Everybody with me? Because we're getting towards the very end.
Yes.
Yay.
Right on track.
How do I send a message to the group?
You go down to the bottom, and I apologize again, Rex isn't reading, and so I can't, it's too much for me to try to read the screen in my paper and the messages. So I apologize, I'm not getting to any of those messages down there, but down below or in your bottom black area, there should be a chat or a raise your hand or some type of way to send a message to everyone.
I went into chat and it says to everyone. I prepared a message, but I don't know how to send it.
I think just push enter.
Just push enter. Well, there we go.
I'm sorry to interrupt.
Go ahead.
Did you go over the portion of GC 400D and E2?
D, I'm sorry, D is in dog?
Yes.
Back in the accounting?
Yes.
I don't know if Rex did or not. I wasn't following every line he went through. D
is in Delta, okay. Losses during period. Can you let yourself in so I can get your computer chat? Okay, disbursements, losses on sale.
He's looking it up, sorry.
And then it also is attached to it. It's a GC 400 E2, and this one is it's a Schedule E. It's Schedule E and Schedule D.
Okay.
For non-cash assessments on hand at the end of the account period, standard and simplified.
So the Schedule D question on 400 GC 400D has to do with losses on sale. And let me see if I can find the mouse. Okay, the Schedule D is losses on sale. So this is where we talked about selling a car that you had a carry value of $31.25 and a sale price of $3,000.
Oh, okay, okay. I was just seeing. Did you also speak on GC 400? I'm just kind of touch base, and I had to step out a few minutes and use the restroom, and I came back.
The other one you'd asked about is Schedule E. That's cash on hand at the end of the period. It's the same as the inventory and appraisal we did in the beginning, but this is at the end of the account period. And that one, you just get the balances for the end of the account period, in this case, March 7th. And then on the non-cash assets, you're bringing forward from the beginning value all your carry values. And then the only thing you're adding here is your estimate of market value. So this 1.1 million you might have gotten off of Zillow or Redfin, and you're not bound by it. If you have stocks, for example, and your carry values down here, you look at the broker statement and see what they show as the market value. So does that cover the question there?
Yes, it does.
Oh, okay.
Thank you.
This is the link for the local rules, if you want it.
Okay.
You're way
Can I also make sure I have exactly how this process goes? So first you get your conservatorship letter, then you have to do within 90 days your inventory and appraisal. And then you do all that on the forms needed is DE 160/GC0040.
A year later.
And then, excuse me?
I'm sorry, your inventory and appraisal needs to be done within 90 days. That's the first step. And then your accounting is done 1 year later. And the petition that we're on right now is done at the same time you turn in your accounting.
Accounting and petition 1 year later. Accounting and petition 1 year later.
Correct.
Thank you.
Okay. And then after the 1 year, after the 1 year of the accounting, then you'll go every 2 years for the appraisal. Correct. Or is it for, okay.
No,
is it for the appraisal?
No. Okay, so your inventory and appraisal will never be done again. That's 1 day in time, and that's the day you got your letters. So your inventory and appraisal is due in 90 days. Your first accounting is due 1 year from the day of your letters, and the petition goes with that accounting. Then after that is approved, you go 2 years, and you have to do an accounting every 2 years. And you will do an accounting and a petition.
You said every 2 years do an accounting?
And the petition, yes.
Okay.
1, 3, 5, and 7.
So you continue the accounting and the petition all through the process of being the conservator?
That's correct.
Okay.
It's very important. Again, what it does is it reduces your liability, because like if you have accounts, this is only really done on conservatorships, guardianships, and probate. And if you think about it, most of the time for trust, somebody who is a trustee, most of the time you'll see in a trust, it'll say waives the accounting. That means it doesn't have to be done, right? So an accounting isn't done, and heirs start getting a little bit antsy about, okay, this, that, or the other. So in my case, or I have 2 cases right now, the accounting was waived. Well, we're getting to the end of final distribution now to my heirs, and I found out money walked away in about $100,000 worth. And I have to figure out before I can distribute, where is this money coming from? Because it's not coming from my pocket. I wasn't in charge. I'm just doing the petition. So, in that case where the accounting was waived, I have nothing. The actual trustee is responsible for everything. Now, if an accounting would have been done and say there was, loss of value of cars or whatever, and it was already reported and the judge approved it, there's nothing anybody can do about it, even if an heir is upset about it. But if you don't get an accounting approved, you are responsible as that conservator for every single dime. You are responsible for every penny. I'm sorry, they go down to the pennies. So if something's missing, you better have a pocket full of pennies that you can replace those pennies. So getting this accounting approved stops your liability. So nobody can go back in that time and say you did something wrong. No, I was upfront with everything I did. The judge approved it. And the only person you can fight is the judge, and not many people go in trying to fight a judge.
Sometimes they do, but I don't think they win very much. So I don't think it's done often.
So a conservator can a conservator rent a conservatees a room in their home?
As long as you could, as long as it doesn't disrupt or change the how the conservatee feels about that. I mean, if they're okay with it and they're, you know, still safe, yeah. Because you're actually maximizing the property for the estate. Okay, I'm going to finish off and continue because we're almost done. I know people want to get going with their day and end the session. So I was already past this point. I'm sorry. Okay, so one of extremely important, and I'm going to tell you number 11. It might not be your number 11, but this number 11 must. And I don't care if you highlight it, underline it, staple it to your top of your computer, but this must be on every single petition, and it's extremely important that you include it. And what it states is you as the conservator have not hired, or if you have, you state you have, and paid anybody who is a family member or anybody who has relationship to you. And the reason being, just think this out and why this is important. So say for instance, I can go hire a gardener, and the gardener's, I don't even know what gardener's rates are. Gardener's rates are, he'll mow the lawn and do the whole yard for $40 every time he comes. Great, okay. But instead of hiring the gardener, I decide my son really needs some money for college, right? He's going to college. What a great job. He can go off and do it. And I tell my son, because he really needs this money for college and a computer, I tell him, okay, I'll let you mow the lawn and I'll give you $50 an hour. Do you guys see any problem with that whatsoever?
Yes.
Right. You are correct. I just said I'm my son $50 an hour of only hiring $40 an hour just because he's my son and I need some money for college. So I'm actually using the conservatee's money much more than I would have. I am using it unwisely to further benefit my own child. So that is an absolute no-no. So again, if you do pay a family member, like say for instance, my son, what if my son said, Mom, I'll do the yard for 30 bucks. Okay, the gardener charges 40. If as long as you do the same quality work, $30, I'm saving 10 bucks. Okay, I can do that. Only thing I would state in here is, yes, I hired my son to do the gardening, and he was only $30 an hour instead of the going rate of $40 an hour to hire an independent person. So I decided to hire him. As long as I state that as a fact and I'm not trying to hide anything, there's nothing wrong with it. What would be wrong with it is if I said, my son really needed college money, so I decided I'm going to pay him $50 an hour instead of the normal rate of $40 because he really just needs the money. Then you have a problem there. And the judge is more than likely going to make you pay back the amount of money that you did wrong, plus a few other things. You're probably going to get a smack on the hand and state, if you continue to do that, you will no longer be the conservator. Sorry. So it's extremely important you include whether there's any family relationships and what they did and what a reasonable price would be if you hired somebody else. Got it?
Yes.
Here's a lot of the description in this paragraph or information for you.
Basically,
Now we're getting down.
Basically, they're just making sure that even though an appointed conservator is for the best interest, it still doesn't mean that you can take advantage of a person just because you have all the rights to all of his possessions.
That's correct.
Okay.
You got to think of it this way. Yes, you have rights because, you know, you are now the conservator, but it's not your money. So you have to take a kind of tiny bit of extraordinary care because you are spending somebody else's money. Like, it's not yours. You didn't earn it. You really don't have a right to it. So that doesn't mean you can go hog wild with somebody else's money when you wouldn't do that with your own. And even if you would do it with your own, you can't do that with somebody else's money. Now, that doesn't mean if the conservatee always buys Louis Vuitton purses that you go run to Kmart just to get her a purse because that's how you would shop. You just have to maintain their lifestyle.
Right, exactly. In order to keep them happy.
Yes. Okay, I'm ready to go off to the conservator's compensation. This might be an interesting conversation to a lot of people. Okay, so the conservator does get compensation. You're not supposed to be doing this for free. And it's up to you whether you decide to take that compensation or not. I have quite a few cases where the conservator doesn't want compensation. They don't want, you know, and hey, fine with that. And then I have a few cases where the conservators do a lot of work. For instance, the conservatee is in a dementia home, so he's constantly running over there, spending time with her, taking her to get her hair done, not now because of COVID, but prior to COVID. You know, they don't, a lot of homes don't do feet pedicure care because I guess some type of liability or something. So, you know, they may have taken them off to that. They may have taken them out to lunch or maybe to the zoo because they loved animals. And so all that time and care and all that stuff that you're doing, you should be compensated for. And again, in some cases, if it's your mother or if you know that the estate really doesn't have a whole lot of money and can't pay you, you can't ask for something that it doesn't have. So say, for instance, you know this person has only $1,000 cash to their name. You can't ask for $2,000 in fees because where are you going to get it? I mean, so think of it that way. So some of this you might be taking on as voluntary. And if it is an estate that, you know, does have enough funds, you are allowed to ask for compensation. And so here is how you would indicate it to the court on why you feel, I can't find my mouse here, why you feel that it is deserved. So in this case, the conservatee has spent over 150 hours. Now that does seem like a lot, but just realize that's over a year. So if you take 12 months, you know, you can kind of figure out how much time this conservator has spent. Now, in this person's case, they're saying the conservatee is my mother. So I visited the care facility where she lives at once a week. I did verify, and this is really important. You know, you can put what you want, but it's nice for the court if you put, you have verified she's getting proper care. If she's not, Put it in there. Oh my gosh, when I saw her, she had bed sores, or it doesn't look like they turn her enough, or it looks like her lips are chapped, and I asked him to provide a chapstick because her lips are bleeding, or it appears that when I walked in, she has bloody noses all the time. If something is wrong, if you put it here, you have documented it. Not only complaining, of course, you would to the facility, but put it here. Put that you complained to the facility about her care, and you may have to think about moving her to another facility. Put to the judge, because he's able to see this, and maybe he can do something about it also, or she. I keep saying the judge is he, but it could be a she. So anyway, in this case,
in this situation, she's asking for the compensation because the conservatee is not, she's not in her possession, so she's taken out of her expenses to come over and to groom the conservatee and take the best care of them. So in that type of situation, that's when you file for conservator's compensation. But what if you have the conservatee, not inside of a home? Would it affect if that conservatee that conservator took like for doing their hair and stuff like that, and those type of things out of their own pay if they have their own money?
Their own money. So you're saying the conservatee has cash in her pocket, and is it okay for you to go over there and cut their hair and then take cash from the conservatee's pocket?
No. What I'm saying is the way it's worded here for the conservator's compensation is more of a situation to where the conservatee is in some type of home. So question that I'm at.
No. It does not matter if they're at home, or in this case, they just wrote this because that's the way it is. But if the conservatee is still at home and you still make several trips to that home, or if you, for instance, my own father, but he's not under a conservatee, but my own father, once a week I go grocery shopping for him and take him groceries, and I make sure I have it on auto pay, but I watch it and make sure that all his utilities are paid, that I pay the DMV. If, I go through all of that, and to do this accounting, I can be paid if I want to. Now, myself, it's my father, so I don't.
Okay, but I'm still, the question that I'm asking is still not being answered, because what if that here the conservatee, they have lots of access. They have lots of non-access and regular access. But I don't understand what's the reason you're asking for compensation? Is because you're assisting them with it, or is it because they don't have the money at that time and you're providing the benefit through your benefits?
No, you just are not allowed to ever be paid unless you ask the court and get approval. So for the whole year that you have provided anything, whether it's just the accounting, or whether it is take them groceries or to a store or anything, they are never allowed to pay you until you get approval from the court. So say I went to go get groceries for my dad, and he said, oh, here's $20 thank you for your gas or whatever. I'm not allowed to accept that under no circumstances whatsoever until I get approval to be paid. So,
okay.
So in this case, You can ask for compensation or you don't. That's a choice. In this case, this person, or this example, this person requests compensation. And as you can tell at the very bottom, for 150 hours worth of work, they're only asking for $500. So they're not asking for a whole lot, but even asking for something, you must get a court approval, and you must not pay yourself until you have received that court approval.
Okay.
Now, in all honesty and all fairness, if my dad handed me $20 and said, here's gas money, thank you for going to get me this stuff, $20 isn't unreasonable, and I really, you'd have to report it on your next accounting, but if he wants to give it to me, I guess I would maybe take it.
But
again,
I mean, could you take it and report it, or would you have to wait and get it in a compensation that's stating that? I mean, because it depends. When you go into that situation, then it goes into the mental stage of the individual. So you wouldn't take it. You wouldn't say, oh, the individual gave me $20 because I assisted him with the gas. Well, no, that wouldn't be beneficial because they're suffering from a mental state. So they could have possibly just did that out of whatever the situation could be. So the courts will look at it, well, no, that's not benefit. But maybe if you said, oh, well, because I assisted the conservatee and this and that, then I took such and such amount to cover the payments for that. Could that be a way to present it to the court, or it always has to be
either way can, as long as it's reasonable. There's a difference between if my dad was to say, here's $200 for gas or something, and I go, oh my God, $200? I only went to the grocery store. I mean, even $20 is kind of, to me, would be a lot. If he said $10, just $10, go get a Starbucks coffee. Thank you for, going to get the groceries. Would I take it every time I did it once a week? No. But if it was every once in a while and he insisted, I probably would take it, because he'd get mad at me after a while that he keeps trying to give it to me and I don't take it. Or I may take it from him and actually put it in my pocket, and next time I go to Starbucks, actually get him a coffee and take it to him and say, here, Dad, I bought you a coffee, and it's with his own money. So, I think you just be pretty reasonable, but as long as, if that's what you do, you report that's what you do, I don't see for $10, $20 any type of trouble you'd really get into. But when it comes to, if it's $1,000 after a long time, yeah, that's too much.
So could that also relate to a question of, I know one of the other ladies mentioned something about the conservative living with the mom or the sister or someone, but once she got conservatorship, then they didn't want her to come back in the home because she had not been paying rent or anything the whole time. So what if she took the mom into her home? I know you mentioned that you can't be paid by the conservator for no reason. So what if she said, okay, well, she put it on her petition, well, I took in my sister, my mother, or whatever, and I took a room out of my home and gave that room to her as the same way it was at living at his mom's. The only difference it is that she wasn't paying over at the sister's, but now she's paying over here, and I charged her the market value rent from renting a room from a facility home.
I would get permission from the court, or ask the court for permission for that before I'd actually do it. Because some courts may say, well, the home is already your home and you had to pay for it anyway. But maybe, I guess, if you said, well, but I could have rented it out to somebody else instead of the mom, or something like that, I'd probably ask the court's approval before I do that kind of thing. I don't have a specific answer for you, but I'm really waffling on the caution on that, because I don't know, I'd get approval first. Because then I can just imagine that sister coming back and going, wait a second, what the hell? I would have kept her if I was getting rent, but oh no, you didn't talk about rent until she gets into your house, and now all of a sudden you get rent. I didn't get anything. Like, so who would be the right person, right? But if you got a court approval first before it happened, then the sister can't say anything. But again, I think if I was
okay,
that
but
sister,
what if you don't have that situation? I'm sorry, I interrupt you. What if you don't have that situation with a sister? You just have that situation with yourself, and you have a disabled person with mental skills, mental disabilities, and also physical disabilities, where you would prefer them to be at your home and rent them out a home and have a provider to come to your home and take care of them, versus you putting them into a home and giving that home, not that you don't want to pay that home, it's just that you would prefer to have him closer to you. You would still feel that would have to be something court ordered first?
I would ask permission from the court first, yes.
Yeah, because you said, the reason why I asked that too, because you said that the petition only comes once a year. Well, I mean, once after the appraisal. So when we were going over the appraisal, I was asking the questions because I was trying to see within the rent area. But you mentioned that the conservator can never charge the rent to the conservatee.
I just probably wouldn't do that without court order.
So what type of, so what would you just put in a note?
Your court order doesn't have to be in the petition. You can do an ex parte. You can ask permission from the court to do anything just through a petition and just get on the court calendar. It doesn't have to be part of the yearly accounting or anything. You just fill out a petition requesting approval for a certain thing that you want to do, and the courts will they'll schedule a hearing and they'll either allow it or disallow. But that, you don't wait for your accounting to get that.
Right. Yeah, you know what? But then too, what if you did it and you put it on the petition later on, and then the judge said, well, you know what? That was not approved and such and such and such. And they said, well, hey, you have to pay back the conservatee.
That would be what they would tell you, yes. And okay. You'd probably be removed as that conservator for making decisions like that, because then they're not trusting you in the future. But I'm going to continue to move on because we're really ran over time and we need to finish this. So again, in this example, there was 150 hours worth of time spent. The conservator is asking for $500 an hour. Again, if it used to be prior to July 1, 2020, that per the local court rules, the non-fiduciary hourly rate was $50 an hour. But I have noticed as of July 1, when the new release came out, that the new rate is $75. So there's been an increase of $25 an hour in fees allowable to collect. So that's completely up to you. But you must state what you did for all those hours. So keeping a log, keeping some type of calendar which states all the care you gave for the year and what you did will be helpful when you're completing this. Now I'm going to move on to if you hire an attorney. The attorney has not been paid and cannot be paid, and they know this. The attorneys do know this. If this is they practice, that they do not get paid until there's been a court order. So in our example, the conservator did hire the services of an attorney to advise him on whatever it was that he needed. No payments prior to this petition have been made to this attorney. the attorney has completed a declaration, which that would be attached, on what his services were. He's also requested compensation, and there, you know, there'll be an attached exhibit. Like I said, this would be the declaration. And the petitioner, meaning you, requests that the court allow you to pay the attorney $3,500 for a reasonable compensation. So you're asking for approval prior to paying the attorney. Okay, I'm gonna go on to the next one. Again, if you have no, you ask for compensation for that attorney. So number 14 is very important. Also, it states whether the conservatee, guardian person was getting any benefits through the Department of Veterans Affairs. It's important to state whether or not in your first petition you must state that. And I think down below here it says whether you would have to state that or not. Also, the state hospital, whether the conservatee has been a patient of a state hospital. And it's because of the benefits of it. I can't give you an exact reason, but you're supposed to put it in there. Okay, in this case, and this is not required, but it is a very nice feature to state where the conservatee is right now. If the judge wanted to make a visit, I'm kidding, no, that isn't the purpose. It just tells them they can kind of off the top of their head, oh, they're in a convalescent home. Okay, now I understand the expenses that went through. Or, oh, now they're in your home, or stuff like this. It just is nice to tell where the conservatee is actually residing. And it becomes part of the public record, actually. May not want to put an exact address. That's interesting. Because again, this is all public record. Right, number 17 is important, and this is a must. And I know I have a few people on here that I've had to state this to several times. But when you turn in your accounting, you must, there's no ifs, there's no ands, there's no buts, there's no please, there's no sorry, there's no nothing. You must submit to the court the original, and I can't say that strong enough, original account statement. If you lose the original statement, you must obtain from the bank a certified copy of a statement. You cannot print statements off of the internet. The statements cannot be photocopied. The statements cannot be, I don't know, scanned or anything like that. The courts have to know that you have not manipulated the document in any way, shape, or form. And the only way they know that is if they get original or certified copies of those bank statements. Now, I've heard every story under the book on why I couldn't submit original copies. The court don't care why. The court don't care, you know, dog ate it, the dog ran over them, they flew in the air, I couldn't get them, they don't care. You have to submit original copies of those bank statements or certified copies. And go with single account. So what they see is that if you report certain expense, they can see it on the bank statement. Again, we what's called a redact of account and maybe even the mailing address yours. The account number, although the mailing address ensures is in the top of the petition, but at least black out all all but last 4 digits of the account. Again, does not want to know the account number and the whole account number. That doesn't matter to them. All they're going to do is take the bank statements and match it to what you filed in your accounting. Okay? So the bank statements, although even if they're delivered that way, you'll see here, even though they're delivered to the court, they're not part of the public record. So if somebody was to pull them, they really never see the bank statements, but they'll see all of the accounting and what you did. Okay, moving on would be capital changes. You will state if there really was any capital changes. And that's pretty much like, for instance, if I was doing, which next year will be quite a bit of these, I'm sure, for people or for like the conservatee during this COVID crisis, say for instance, their stock portfolio like crashed into the garbage. There's many of us out here, me one of them, who have lost tons of money in the stock market during all this COVID crisis. I myself would put on here, it's due to the COVID and how much the stock crashed, and had nothing to do with me, had nothing to do with whether it was in the proper portfolio or what it was. I myself will be stating in many of my accountings later on that are going to be due that if there was a crash in the market, or if my conservatee lost a lot of money in the stock market due to COVID, and that's the reason why. So that later on, an heir or somebody else can't come back and say, oh, I purposely put it in funds that crashed and it's my fault, and they want me to replace what was lost or whatever reason. So again, if you do not have any changes or there's nothing to report, then you don't have to include stuff like that. Or you can, if you want to, just to get it approved, state there's been no changes, and the judge will sign off on.
Is this all much the same for a decedent's estate petition?
That's correct. It's the exact same one.
Okay.
Okay.
I'm
so
sorry,
your
I didn't hear that.
It's the same for a decedent's estate.
Oh, okay.
Okay, so the statement of liabilities in this case, depending on if you have one, for instance, this one has a promissory note secured against the property, which means the house is not paid off. You would state, you know, there is a note, what the balance is. It calls for monthly payments. It bears interest. There are no balloon payments, and it is current. So basically, you're just telling the judge there's a note on the house, and you know you're making payment, and you know it's in a really good interest rate, so on and so forth. The next question, which a lot of you may not know or understand what this is if you're filing pro per, but the special notice. So I can tell you what that actually means is, say you have a case, you're a conservator for somebody and it's your brother. Okay, I'm going to use that example. So you're a conservator, the conservatee is your brother, and let's just say I was your brother's girlfriend prior to the crash that happened. So I was your brother's girlfriend. And I don't trust you. I think you're sneaky, or I just may not like you. I don't know, for whatever reason. I myself can pay $40, and that's all it is. Pay $40, and I file with the court a special notice. That means every single time you file any document, I'm talking any document whatsoever, you have to send me a copy of that document. Anytime you ask the court for any approval, guess what? You're sending me a copy of that document. Anytime you have a court hearing, guess what? You're sending me a copy of that court hearing and telling me so I can attend that court hearing. That is what's a special notice. Anybody can pay $40 and become noticed on anybody else's estate or court hearing case. So again, I could be a girlfriend, I could be a friend, I could be a neighbor, I could not even know anything about you, but I still want to just have fun and spend my money and time and file a whole bunch of special notices. That's what this question is right here. So you do need to tell the judge, although he can look at it through his file, we're trying to alleviate that whether anybody has filed special notice on your case or not. If somebody does file for special notice, you know it immediately and you're told right away as soon as they file it. If you have never received somebody's request for special notice, that means there is no request for special notice. It is rare. I'm telling you, it really is rare, but it happens. And it's just dependent on the circumstances of the case, whether one is filed or not. I can tell you that on quite a few of my probate cases, they file requests for special notice because maybe the granddaughter is the administrator or some non-family member is the administrator, and they just want to make sure they get every notice that's done. They should anyway because they're an heir, but you don't have to be an heir to file a special notice on an account or somebody's case. Okay.
Tammara? Where do
hon.
we get the documentation, or where do we get the form to file a special notice?
That will be on the, you can look up at any court's, any court website. It will be part of their forms if you did a search. I don't know.
Judicial council looking.
Same thing. So you can look up on the internet, request for special notice form. They will show you the judicial council form. You could just type in request for special notice and I'm sure the form will come up. I think it's it's a very, very, very simple form. And again, if you have like an estate and maybe, okay, say you have a trust you have a trust and there was a trust written, but something happened and you want the judge or you needed to file a probate because you need special instructions from the judge. And one of the uncles was not named in the trust, say for instance, but he still wants to make sure that whoever's running it's running it properly, he may want to file a special notice. I mean, there's so many different reasons why people may want to file a special notice on the case. It just makes sure that they stay informed about everything that's going on with the case.
Okay. Okay.
Tammara, I have a quick question. In the event where a conservatorship is in place and the accounting has been done, but the family wants to add a co-conservator, which would be a petition to amend, is the accounting process the same?
No, well, your question would be more that there would be a petition for a co-conservator that would need to be added and approved, but still the person responsible for the accounting is the original conservator, and it would still run on that time frame. Does that make sense? Whether you add whether you add a conservator or not doesn't change the time frame or doesn't change the responsibility of the accounting.
All right, thank you.
Thank you. Sorry, I'm getting super close to the camera, but I'm trying to hear because you're really faint. Sorry. Okay, so I'm gonna move on to.
Tammara, this is Jim Hudson. I'm sorry to interrupt. I have a question. I'm going to back up, just back up a moment to the bank statements. We have to attach a statement for just the final statement for the account period. So if the account period was ending at the end of this month, it only has to be that one bank statement. Is that correct?
No, sir. No, sir. It has to be the monthly statements for every single month that you're doing the accounting for. So if it's an entire year, you will have 12 monthly statements. If it's 2 years that you're doing your accounting, you will have 24 statements, and that's for every single account you have. So say, for instance, I have an account currently that has about 7 different bank accounts. There's a checking, there's a savings, there's an IRA, there's annuities, there's, I must have a bank statement for every month of my accounting for every account.
Okay, and so because a lot of the banking these days is your statement is electronic, in that instance, I have to have that electronic statement certified by the bank somehow?
That's correct. I would actually, in that case, go in and tell the bank that you must have original documents you submit to the court and make them change it from online banking to actually sending you a statement.
Okay, thank you.
Rex wants to say something now.
On the banking statements, I recommend that you require the bank to give you the canceled checks. I get them from Wells Fargo, and it's a good idea because now you get an image of the canceled check at the end of each month. And if anybody questions who you paid it to, you've got the front and the back, and it may cost you $10 a month or more. It's well worth it in my view.
Okay, thank you.
So how much do you charge, like I'm a legal document preparer, how much do I charge a person to do this? It sounds like a lot of work.
Honey, that's totally up to you. Everybody has their own rate, whether you decide to do it per hour or whether you decide to do it on a flat fee. I can tell you, I myself typically take about 20 hours per accounting to do it. So that can give you an idea. I don't know.
The fiduciary fees also for the same, I would think.
Oh, I don't know how to work his calculator. Hour, 20 hours.
20 hours times 75.
Yeah. Boy, this is crazy. I do accounting and don't know how to work his calculator. So, okay, so even if it was about 20 hours at the 75 non-fiduciary rate, you're talking 1,500. Sometimes they can go, it depends on how complicated, how many accounts. Do you have one account or do you have 7 accounts? So mine can run between 1,500 and 3,000. It just depends.
Thank you.
I think they all change based on how much detail and how much stuff you're going through. Like, for instance, if I have one that a lot of stocks change in value, or there's a lot of sales and reinvestments and drips and stuff like that take me entering every single transaction, then it is what it is. I will say for completions, for whoever's completing them and who's ever paying for somebody to complete them, that the average, and I'm talking average rate that I've seen and that I use, is about 2,500 per accounting.
Okay.
but some can be a whole lot lower if they're very simple, one or two transactions which you're only paying a care facility, and they may only have retirement income. I mean, if you have something little like that, I mean, it's not going to take you that long at all. But and the first couple of times it's going to take you a whole lot longer. So maybe you flat fee it or something like that. Or, but ask up front, even if you're hiring somebody to do the accounting, ask them how much they charge, and just know that regardless of what it is, you cannot go beyond the $75 an hour, or you're probably going to have to pay for some of that yourself.
Thank you.
Does that make sense? Okay, I'm ready to move on. Okay, so
I have one question before we end. When you file for conservatorship of an individual, if they don't have those type of property, only thing they have is just basically like a bank account and Social Security, and that's basically it. Do you have to file for the petition in? I mean, the request in for the estate also, not just the person?
Yeah, well, you're dealing with money, hon.
Okay, that's what I wanted. So if I only put, because I wasn't sure how that works, this is something very new to me. So if I put it in for just the person, I would do an amended request for the estate. Is that correct?
Likely, yeah.
Rex says likely yes. I don't know that answer.
Okay, thank you.
What if they only have Medi-Cal?
Well, you would still have to do an accounting because they're going to have expenses, but that would just be a smaller accounting that shouldn't really take a whole lot of time at all. But you have to record that Medi-Cal payment every single month on a schedule. And if whatever expenses come out of that, then you'd have to include that on the other schedule, and then just make sure they balance, and then do this petition. Just because they only have one or two things doesn't get you out of the accounting. If there's any money whatsoever that they have, you must account for it every year, or for the first time, and 2 years thereafter.
Okay, thank you.
Okay, I'm gonna go on to the very end. And again, if you guys need to leave because you need to, I've taken too long, then please go for it and leave, and you can repeat the class at any time. Okay, so at the very end, okay, we've now got to the end. We've indicated everything we did on the accounting sheet, and everything has been, we've explained ourselves. So now at this point, we are stating, what do we want the judge to do with this? Okay, now I've stated all the facts. Now I've provided all the details. I gave you a summary. I did everything I did. Okay, I'm the judge. What do you want me to do with it? Okay, so this is what we're saying. So I, as the conservator, I can pray that you approve and settle this account. It's really important you say both words. So you're saying, Judge, I want you to give your blessing. Okay, that the acts that I did or performed during this account period only are approved. So that means selling the car, selling the furniture, selling the vacation house. You approve all that I've done because I told you I did it properly and purposefully. Oh, well, you'll list them separately. I see now. So I sold the automobile. I sold the furnishings. And now lastly, I'm asking for $500 worth of compensation. And I'm asking that you approve the $3,500 for the attorney. If I had one, but in this case example, we had one. Then lastly, I'm saying, and any other thing that you want to add in here that you want to approve, deny, or anything else you want to do, because you have full jurisdiction to, you know, I'm under your guidance. So anything you want to add, prove, or whatever, please feel free to do so. Then you're going to date it, and you will sign it as the conservator. In this case, this line would not be here. This is only if an attorney. If there is no attorney, again, you will not have this details. Now we have one more page, and it must, I cannot, how many times I've seen them delivered to the court and they do not have this verification. The verification is very, very important, and nothing will be approved, looked at, or whatever if you don't have this verification. And if you ever got back probate examiner notes that says, please include a verification, you're gonna know what that means, because I'm not gonna let you go without knowing this. So what this verification is at the very end, and you must put it, is you state under penalty of perjury, under the laws of the state of California, that this is true and correct. I know you guys have seen this other ways. Now they make you do a verification. Before it used to be that you just included this one line item at the end of whatever document you were signing, and that meant it covers everything. No, not in this. This will state that under penalty and perjury, under the laws of state of California, that you are certified this is true and correct. So you date it, and then again, you sign it and type your name. Once that is, a lot of times I also like to do, and this is just me, is sometimes I'll state what city I'm in, because that makes a difference of who really has jurisdiction of if I don't include it, or if for some reason I sign this under penalty of perjury and it's all a lie, where the jurisdiction would be, which means what court would hear the case would be dependent upon where I signed it, on who would be able to look over my back and tell me I did wrong. So a couple other things just real quick. I don't know if Rex went through this because I didn't really pay much attention, but he did good. So he went through the checkbook register. Oh yeah, his statement of accounts. I'm gonna slide through these real quickly because I know there's information. Actually, he's standing here, so I'm going, I already went through the verification. He's standing here, so I'm gonna let him continue and I'll sign off. And if there's a question you have for me specifically, feel free to contact me. You can either send me a private email, which I can give you an email address, or you can send it to Rex, and I can also I can also answer the questions. Otherwise, I'll let him complete it. I thank you guys for listening to me. And if you need to take the class again, please feel free. You can do so. Otherwise, thank you for listening.
Can I ask one question? Can I get the address again for receiving the certificate? The email?
Yes, that would be Rex's address, which is his name, Rex. Okay, he's gonna take you. He's gonna take you through because he wants to send off with his regular talk. So bye guys, thank you.
Thank you. Thank you.
Okay, we just had a question of where to ask for a completion certificate. Here's the email address on the screen, Rex Crandell at astound.net.
Rex, can you spell that out for me again?
Right there.
Rex is Romeo Echo X-ray, Crandell, phonetically, Charlie Romeo Alpha November Delta Echo Lima Lima at
You know what? You're excuse me, you're losing me. Can you just say the letters? You don't have to give me any examples.
Okay. REX CRANDELL at astound.net.
Not so fast, not so fast. REX CRANDELL
at astound ASTOUND.net.
Okay.
And so the other thing is, if somebody has a question, you could send us an email. That's fine. We'll be happy to answer questions to participants. You could call at 925-934-6320 or 1-800-464-6595. Y también si ustedes tienen clientes que no podría hablar en español bien, nosotros ofrecen servicios en español también si quiere o si tienen la necesidad. Another thing that we have available is an Excel spreadsheet that is for court accounting. We sell that for $50. You should have gotten 2 packets from us for the class. In the second packet that I haven't gone over, it includes the ordering information for that Excel. In the other packet that we haven't gone over today, there's information about common errors in court accounting put out by the Alameda County Superior Court. The other thing I wanted to mention was that there's a book, Margaret Hand, who's an attorney that I know in Orinda, has written a fiduciary accounting book, okay, handbook. Don't think you're going to learn how to do accounting with this book. There's way too much. It's like about a $220 book, but what we use it for is reference looking up some unusual transaction. So that is available, and the publisher is CEB, Continuing Education of the Bar in Oakland. So that's available. And as I mentioned previously, the guardianship conservatorship handbook is also available online. And the link to that is on the screen, www.courts.ca.gov/documents/handbook PDF. So that's also a good resource. If you decide you want a completion certificate, send us an email. We'll be happy to respond to that. There was a question earlier about the local rules for Contra Costa County, and I don't think I can show you the link, but if you can write fast, it's www.cc-courts.org/local-rules/docs/current local court rules.pdf. And there's the court rules by paragraph, but this happens to be in a guideline attachment 2. And it's on page 70 and 71 of a document that's 186 pages. But refresh what we're talking about is that when you go to turn in your billing chart for your petition, professional fiduciaries can charge $125 to $195, and fiduciary staff members $95 to $175. Standard hourly rate for non-fiduciaries is $75 an hour. So that also includes, since the fiduciary is responsible for doing the accounting, I would show it as a separate line item for your bill when you want the judge to approve it so that you can get paid. And don't make the mistake of taking any money from the accounts to pay yourself until the end of the account period and the judge signs off, both for if there's an attorney representing the guardian, conservator, or trustee, and or probate, and also the representative, guardian, conservator, executor. We've gone overtime. I apologize for that. I think it's just so much enthusiasm, and accounting is just so fun. Yeah, it's not that bad, but it's a fact of life. And when you're a guardian, conservator, or fiduciary, you are flat responsible to everybody, and it's the highest duty of care, and the courts hold the fiduciary personally liable for things, and so you need to do a good job, and I don't think you'll have any problem. If you have questions, you can look it up or contact somebody. We'd be happy to steer you in the right direction. But anyway, I'm going to close now because we've gone over, and I thank everyone for participating. I hope you got value from the presentation, and we'll talk again in the future. Bye.
Thank you. Bye-bye.
Thank you all.
Thank you.
Okay. Oh, if anybody's still on, we can send you an evaluation through the Contra Costa County Law Library. There's a evaluation form that you could fill out, and if so, then it's given to the judge. But anyway, I don't think I sent it out. Okay, bye again.
Okay, all right. Bye-bye. Thank you.
Thanks.